from office. The report of the Departmental Committee on Justice and Legal Affairs, to which the petition was committed, is instructive. With regard to its findings, the committee report tabled before the House on Tuesday, 19th August 2014, states, and I quote, 1. The Office of the Attorney General is not listed either as a constitutional commission or an independent office under Article 248, clauses 2 and 3 of the Constitution. 2. The procedure for removal contemplated under Article 251 of the Constitution cannot be used for removal of the Attorney General. 3. While the Attorney General is a member of the Cabinet under Article 152, Clause 2 of the Constitution, he is not a Cabinet Secretary, and therefore the process of removal of a Cabinet Secretary cannot apply in his case. 4. Whereas Article 132 of the Constitution gives the President power to dismiss the Attorney General in accordance with Article 156, the same Article 156 does not have provisions on removal of the Attorney General. 5. The Office of the Attorney General Act has made provision for the grounds for removal, but does not set out the procedure for removal. And 6. The power and discretion to remove the Attorney General is vested in the President, find Article 132, Clause 2, Paragraph B of the Constitution. Consequently, the committee proceeded to recommend and I quote, the Office of the Attorney General Act 2012 should be amended to provide for express provisions on the procedure for removal of the Attorney General from office by way of an all-inclusive process, close the quotes. Thereafter, a bill was published in the name of the committee to actualize these findings in law. However, by the end of the 11th Parliament, the bill had not been concluded. It therefore lapsed. Honourable members, in light of the previous inconclusive process undertaken on a petition to remove the Attorney General to Mr. Khalifa on the 6th of October 2021, advising him of the inability of the House to process his request. The letter highlighted the lack of express provisions in the Constitution, ordinary legislation, and the National Assembly standing orders on the manner in which the process of removing the Attorney General from office may be initiated. A binding recommendation for such removal may be made by any person or body. Honourable members, you will recall that as per the provisions of Article 109 Clause 4 of the Constitution, only a member or a committee of this House has the power to introduce legislation for consideration and debate. The Departmental Committee on Justice and Legal Affairs may wish to consider reviewing the Act to provide for the procedure for removal of the Attorney General. The matter is not within the authority of the National Assembly to deal with. I thank you, honourable members. Members, come in, please.
We have numbers for the other. We have numbers for the one you got. That's it, come.
Let me do this one over. President.
Yes, let me messages.
Yeah.
You should have a communication.
Member for Kilifi North, perhaps you could just stay a bit. You have not even stayed for 1 minute.
Order number 3, messages.
Member for Moya, please take your seat. Member for Moya, please take your seat. I know you like sitting where the member for Meru is sat today. just behind the Honorable Sankok. Honourable members, says this a message from the President. Honourable members, standing order number 42, subsection 1, related to messages from the President provides that, and I quote, the Speaker shall read to the House any message from the President delivered to the Speaker for communication to the House, close the quotes. In this regard, therefore, honourable members, I wish to inform the House that I have received a message from His Excellency the President dated 19th of November 2021, conveying that he intends to deliver the 2021 State of the Nation Address to Parliament pursuant to Article 132, Clause 1 of the Constitution. Honourable members, the said Article 132, Clause 1, paragraphs B and C of the Constitution state, and I quote, "The President shall be address a special sitting of Parliament once every year and may address Parliament at any other time, and C, once every year, Roman 1, report in an address to the nation on all the measures taken and the progress achieved in the realization of the national values referred to in Article 10. Roman 2, publish in the Gazette the details of the measures and progress under subparagraph 1. And 3, Roman 3, submit a report for debate to the National Assembly on the progress made in fulfilling the international obligations of the Republic." Close the quotes. Honourable members, pursuant to the above provisions of the Constitution and standing order number 22, subsection 2 of the National Assembly standing orders, therefore, I wish to notify all members that a special joint sitting of Parliament will take place on Tuesday, 30th of November 2021 at 2:30 p.m. in the National Assembly main chamber, Parliament buildings. I'm aware that the offices of the clerks of the Houses of Parliament have since commenced preparations for the day, including official invitations, which will be sent out in the usual manner. I also direct that the clerk to ensure that the notification of the joint sitting is published in the Kenya Gazette for the information of members and the general public. I thank you, honourable members. Honourable members, member from Bonchari, please. Is it Bonchari? Please come in. Please take your seat. Take your seat. Honourable members, this communication from the chair, being number 46 of 2021, relates to the import of the judgment of the Court of Appeal in Civil Appeal number E084 of 2021 on the legislative functions of the National Assembly. Honourable members, you will recall that last year on the 29th of October 2020, the High Court in Nairobi delivered a judgment that, among other things, purported to nullify 23 acts of Parliament that had been passed by this House. You will also recall that following the High Court judgment, I did issue a communication to this House to the effect that the National Assembly, being dissatisfied with that decision, would appeal the High Court judgment. Honourable members, to this end, I wish to inform you that last week, on Friday, 19th of November 2021, the Court of Appeal, sitting in Nairobi in Civil Appeal number E084 of 2021, delivered its judgment on our appeal and set aside the judgment of the High Court. In particular, the Court of Appeal made several orders. Allow me to highlight part of the orders of the Appellate Court point by point, because they have a huge bearing on the legislative processes of this House. Firstly, honourable members, in its decision, the Court of Appeal declared 21 acts of Parliament out of the 23 which the High Court had declared as being unconstitutional for want of Senate participation to be constitutional and valid. It will be recalled that this House passed the same laws without Senate participation on the strength that they did not concern county governments, as they were dealing with functions of the national government under Part 1 of the 4th Schedule to the Constitution, and all were money bill, that did not contain provisions affecting the county governments. The Court of Appeal, in its judgment, agreed with this interpretation of the National Assembly and consequently upheld the constitutionality and validity of the 21 Acts of Parliament. In brief, the laws that were declared to be constitutional are as follows. The Public Trustee Amendment Act number 6 of 2018, the Building Surveyors Act number 19 of 2018, the Computer Misuse and Cybercrime Act number 5 of 2018, the Statute Law Miscellaneous Amendment Act number 4 of 2018, the Kenya Coast Guard Service Act number 11 of 2018, the Tax Laws Amendments Act number 9 of 2018, the Statute Law Miscellaneous Amendment Act number 18 of 2018, the Supplementary Appropriations Act number 2 of 2018, the Finance Act number 10 of 2018, the Appropriations Act number 7 of 2018, the Capital Markets Amendment Act number 15 of 2018, the National Youth Service Act number 17 of 2018, the Supplementary Appropriations Act number 13 of 2018, the Health Laws Amendment Act number 5 of 2019, save for the amendments made to sections 3 and 4 of the Kenya Medical Supplies Authority Act, in brackets KEMSA, and the Act made various amendments to health-related statutes on matters relating to health policy, including the Pharmacy and Poisons Act, Cap 244, the Medical Practitioners and Dentists Act, Cap 253, the Nurses Act, Cap 257, the Kenya Medical Training College Act, Cap 261, and the Nutritionists and the Dietitians Act, number 18 of 2007, among others. Number 15, the Sports Amendment Act number 7 of 2019, the National Government Constituencies Development Fund Act of 2015, the National Cohesion and Integration Amendment Act of 2019, the Statute Law Miscellaneous Amendment Act of 2019, the Supplementary Appropriations Act number 9 of 2019, the Appropriations Act of 2019, and the Insurance Amendment Act 2019. Honourable members, as stated earlier, the Court of Appeal declared 21 out of the 23 acts constitutional, and only 2 acts, this being the Equalization Fund Appropriation Act number 3 of 2018 and the Circle Societies Amendment Act number 16 of 2018, were declared to have been unconstitutional. In terms of the objects of the 2 acts, the Equalization Fund Appropriation Act number 3 of 2018 appropriated funds for expenditure by the national government for the direct use of monies from the Equalization Fund. It is therefore a spent law. The Circle Society Amendment Act number 16 of 2018, on the other hand, sought to provide that the Circle Society's regulatory authority may establish and operate an electronic filing system for purposes of electronic filing of the statutory returns and documents or other information required to be furnished to the authority. Honourable members, the Court of Appeal further declared the amendments made to sections 3 and 4 of the Kenya Medical Supplies Act, Authority Act contained in the Health Laws Amendment Act to have been unconstitutional. Only those 2 sections. To this end, honourable members, in light of the Court of Appeal judgment, a pertinent question that arises is how the House should proceed to reenact the laws that have been nullified. With respect to the Equalization Fund Appropriation Act number 3 of 2018, the objectives of the long title of the law reads as follows, and I quote, "An Act of Parliament to authorize the issue of a sum of money out of the Equalization Fund and its application towards the service of the year ending 30th June 2018, and to appropriate that sum for certain public basic services and for connected purposes." Close the quotes. Honourable members, you will agree with me that this particular act being an annual appropriations law, cannot be resuscitated as it is now spent. However, the decision of the Court of Appeal will have to be adhered to by the future houses when enacting the annual equalization fund laws. It is, however, worth observing that under Article 204 of the Constitution, the equalization fund was meant to be a 20-year measure to assist the marginalized areas, cater for basic services such as water, roads, health services, and electricity connectivity. The said fact is that whereas more than half of the statutory period has now lapsed, the fund has been largely moribund, since every step to actualize it has been met with endless litigation. Honourable members, with respect to the Circumstances Amendment Act 2018, I direct the clerk moves with speed to facilitate the reintroduction of the bill in the House in the exact text as it was originally passed by this House in 2018 for reconsideration in an expeditious manner and forwarding the same to the Senate. However, with respect to the amendments made to sections 3 and 4 of the Kenya Medical Supplies Authority Act touching on the functions of the authority as contained in the Health Laws Amendment Act number 5 of 2019, I note that there is presently a Health Laws Amendment Bill 2021 at second reading stage. Consequently, the amendments may be proposed to the Health Laws Amendment Bill 2021 for consideration by the House at the committee stage. Subsequently, upon passage, the bill shall be forwarded to the Senate for consideration also. That way, this House will have discharged its legislative role on the two impugned laws in compliance with the findings and decision of the appellate court. Honourable members, moving on to the other orders of the Court of Appeal, the Court also made a declaration that the concurrence process envisaged in Article 110, Clause 3, only applies to bills concerning counties within the meaning of Articles 109 to 114 of the Constitution. Indeed, as you are aware, Article 103, Clause 3, Article 110, Clause 3 of the Constitution provides that, and I quote, before either House considers a bill, the Speakers of the National Assembly and the Senate shall jointly resolve any question as to whether the bill is a bill concerning counties, and if it is, whether it is a special or an ordinary bill. This has been a major point of departure between the two houses, and as you are indeed aware, the High Court had made a declaration that all bills must be subjected to the concurrence process, notwithstanding the distinct legislative mandates of each House and the asymmetrical nature of our bicameral parliament, in which each House has distinct mandates, with the Senate having limited legislative mandate, as indeed observed by the Court of Appeal in paragraphs 72 and 73 of its judgment. And in their judgment, the distinguished judges held as follows in paragraph 98. I quote, "Therefore, it was an error by the High Court to find that it is a condition precedent that any bill published by either House be subjected to the concurrence process." Close the quotes. Honourable members, the finding by the Court of Appeal on this matter is that only bills concerning county governments as espoused in Article 110, Clause 1 of the Constitution would be subject to the concurrence process. The Court correctly held that Article 110, Clause 3 can only be interpreted in the context of the law-making roles and procedures of the Senate and National Assembly as specified in Articles 109 to 116 of the Constitution. Maybe the members who are at the door gate can come in. Members, I shall proceed. In this regard, the Court of Appeal has now settled that Article 110, Clause 3 of the Constitution, and this is important, shall not be applicable on any or every bill that originates from the National Assembly, but only on bills that concern county governments within the meaning of Article 110, Clause 1 of the Constitution. We applaud the Court of Appeal for upholding the provisions of Article 110.3 of the Constitution and the distinct roles of the Houses of Parliament. Honourable members, with respect to the constant insistence by part of the Senate that the speakers of the Houses of Parliament should form a mediation committee akin to the one under Article 113 of the Constitution to offer advisory on the question of bills concerning county governments, the distinguished judges of the Court of Appeal held as follows in paragraph 102 of the judgment. Quote, we however need to point out and clarify that our interpretation of Article 110, Clause 3 leads to a conclusion that the mediation process under Article 113 of the Constitution is not applicable to the concurrence process in Article 110.3. The provisions of Article 113 are clear that they only apply when there is a deadlock in the consideration and passing of ordinary bills concerning counties by the National Assembly and the Senate. The mediation process, therefore, applies during the enactment process of a bill and not before consideration of a bill, which is when the concurrence process under Article 110.3 is relevant. In our opinion, the concurrence process under Article 110.3 is one that is solely and exclusively within the mandate, powers, and control of the speakers of the two Houses of Parliament, who must resolve any question arising as to whether a bill is one concerning counties or not before its consideration. Close the quotes. Honourable members, further, the Court of Appeal also made orders touching on the legislative procedures and rules of this House. Firstly, the Court ordered that any bill or delegated legislation that provides for or touches on the mandate or powers of the Parliamentary Service Commission must be considered by the Senate, as it directly affects the Senate's ability to undertake its constitutional mandate, including its ability to consider bills that affect counties. In this regard, moving forward, in terms of the legislative procedures, any bill that provides for or touches on the mandate or powers of the Parliamentary Service Commission shall be forwarded to the Senate after passage by this House for consideration. Honourable members, secondly, the Court also did make orders in regard to our legislative procedures relating to the rules of this House, and I quote, where the speakers of the House concur that a bill is one that concerns counties pursuant to Article 1094, the bill must be passed in accordance with Articles 110 to 113, 122 and 123 of the Constitution and the standing orders of both Houses, and is not subject to Article 114 of the Constitution. Honourable members, Article 114 of the Constitution is the provision on money bills, and the finding of the Court is that where the speakers of the Houses agree that a bill is one that concerns county governments, then such a bill shall not be subject to Article 114 of the Constitution. The Court of Appeal, however, observed the following in paragraph 127 of the judgment with respect to money bills, and I wish to quote the distinguished judges. Quote, it is instructive that unlike Article 1094 of the Constitution, where application of Article 110.3 of the Constitution is expressly required, in the case of enactment of money bills, the Constitution is silent on the involvement of the Senate. As such, it is safe to conclude that all money bills passed through the Speaker of the National Assembly, whether commenced by the Senate or in the National Assembly for him or her to ascertain whether or not it is a money bill, and all money bills subjected to the Budgetary Committee dependent upon their outcome are passed by the National Assembly without reference to the Senate. Close the quotes. Honourable members, I also note that the High Court, in its judgment, and also declared the National Assembly Standing Order 143, which requires bills originating from the Senate to be subjected to the money bill determination as offending the Constitution. The Court of Appeal did not, however, make any determination on Standing Order 143, as it was not part of the items that were set for determination at the appeal. Indeed, the Court of Appeal also observed in paragraph 260 of this judgment as follows, and allow me to quote, "We note that there was no appeal in respect of Standing Order number 143, clause 2 and to 6, which was also declared and considered by the High Court. This being the case, there was nothing for us to determine in this regard." Honourable members, in light of the foregoing, the High Court judgment which declared National Assembly Standing Order 143 and Constitution still stands. Additionally, I also note that the Court of Appeal in its orders also declared that provisions of Standing Order 121, subsection 2 of the National Assembly Standing Orders, which provide for the procedure for consideration of bills concerning county government, is inconsistent with Articles 1094 and 110 to 113 of the Constitution, and therefore null and void. Honourable members, to this end, it may be prudent that the Procedure and House Rules Committee, which is currently undertaking a review of the standing orders, does also undertake a review of Standing Orders 121 and 143 with a view to aligning them with the Constitution as guided by the court decisions. Honourable members, finally, the Court of Appeal also did make a determination on our cross petition, which we had filed in the High Court. You will indeed recall that the National Assembly had also filed a cross petition in the High Court seeking, among other things, the following declarations on a number of constitutional questions which are of concern to the members of this House. One, we had sought in the cross petition a declaration that the Senate had a limited role of oversight of state and state organs under Article 145 of the Constitution, limited to considering and determining any resolution to remove the President or the Deputy President. Two, a declaration that to the extent that the Senate has established committees duplicating the mandate of the committees of this House and purporting to exercise oversight over matters that fall in the exclusive domain of this House, the Senate of Kenya is in violation of the Constitution. Three, we had also sought a declaration that the Senate purported action of establishing and facilitating and or causing to be facilitated committees duplicating the mandate of the committees of the National Assembly and county assemblies amounts to imprudent and irresponsible spending of public money contrary to Article 201 of the Constitution. Fourthly, we had also sought a declaration that the National Assembly and the sole mandate of approving persons nominated by the President as state or public officers to serve in state office and public office in the national government. Five, we had also sought a declaration that Article 95, clauses 4 and 5, confer the National Assembly the exclusive mandate of oversight of state officers. And lastly, we had also sought a declaration that establishment of the offices of the Senate, leaders of the majority and minority, through Senate Standing Order numbers 19 and 20 is contrary to Article 108 of the Constitution, as the offices are not created or established or contemplated anywhere in the Constitution. Honourable members, it is notable that the High Court converted the National Assembly's cross petition to a response to the consolidated petition and failed to consider the issues raised therein. In this regard, the Court of Appeal held that the cross petition raised significant constitutional issues, and the High Court ought to have given procedural guidance on dispensing with the issues. To this end, the Court of Appeal in its judgment made the following order, and I quote, "We hereby remit the appellant's cross petition filed in Nairobi High Court Constitutional Petition number 284 of 2019 back to the High Court for consideration and determination of prayers numbers 7 to 22 of the cross petition." Close the quotes. Honourable members, in light of the foregoing, I will be giving directions to the Clerk of the National Assembly and our legal counsel on how to proceed as with respect to implementing the orders of the Court of Appeal in this regard. Honourable members, having highlighted the orders of the Court of Appeal, and even as we proceed as guided by the Court of Appeal, allow me to also note that there may be ensuing issues arising from the manner in which the Senate had applied the High Court judgment, which has since been set aside. One of the ensuing issues was the erroneous interpretation and application by the Senate of the High Court judgment, where it did proceed to republish bills when this House was already seized of similar Senate bills which were undergoing consideration at different stages by the committees and the House. Honourable members, as I have guided this House before, I shall stand guided by the reports of the relevant committees considering similar versions of Senate bills on their determination on which of the bills should be proceeded with and accorded priority in the House. The other ensuing issue arising from the erroneous application of the High Court judgment is in respect to the National Assembly bills in the Senate, whose consideration the Speaker of the Senate had halted on the grounds that no resolution had been made between the two speakers in terms of Article 110, Clause 3 of the Constitution. To this end, and in light of the Court of Appeal judgment, I shall be consulting my distinguished colleague and counterpart in the Senate for reconsideration of his decision halting the consideration of the National Assembly bills in the Senate. In this regard, I have in mind the Kenya National Library Service Bill 2020, the Parliamentary Pensions Amendment Number 3 Bill 2019, the Public Service Values and Principles Amendment Bill 2019, the Cancer Prevention and Control Amendment Bill 2020, the National Youth Council Amendment Bill 2019, whose consideration was stopped in the Senate. Honourable members, from what I have just highlighted, you will agree with me that the legal dispute between the two houses and the different interpretations of the High Court judgment adopted by both houses was threatening to frustrate the legislative business of Parliament, its committees, and individual members, and the conduit relationship between the two houses. It had also threatened to negate the legislative authority of the institution of Parliament as provided for in Articles 94, 95, and 96 of the Constitution. Honourable members, I must therefore commend the judges of the Court of Appeal for settling all the pertinent constitutional issues, and more so for upholding the Constitution and the High Court decision in the famous Pevans East Africa case by applying, in brackets, the pith and substance test to establish whether a bill concerns county governments. Please join me in lauding the members of this House who have been instrumental in offering counsel on the matter, the Clerk of the National Assembly, our internal and external counsel for their contributions and enriching submissions to the case, which made it a success. Honourable members, I am however cognizant of the fact that the judgment of the Court of Appeal does not call for celebrations, as it is not a case of who has won or who has lost. It calls for sobriety. More so, it should be seen as a learning lesson for both houses to live in committee and restrain from taking each other to court. Indeed, when we drag each other to court, it is the people of Kenya who lose. Yet they are the very reason that the two houses were established. When legislative processes of either house stop, it only means that Parliament cannot use or exercise its legislative power to respond to the issues of concern to the people. I therefore call on both houses to work together and collectively serve our people, remembering that in the end, whenever there is a court dispute between houses, it shall never be a question of which house won, but rather, how did Wanjiko lose? Consequently, with the citizen in mind as Parliament, we must therefore always find ways of amicably settling our disputes outside of the courts. To this end, I will continue engaging my distinguished colleague and counterpart in the Senate with a view to unlocking any impulse that may arise in the legislative processes. Honourable members, in summary, following the decision of the Court of Appeal, my guidance is as follows. 1, that the leader of the majority party or the Departmental Committee on Trade, Industry and Cooperatives reintroduces a bill for an act of parliament to amend the Circle Societies Act as contemplated in the Circle Societies Amendment Act number 16 of 2018, which was declared unconstitutional by the Court of Appeal, for expeditious reconsideration by the House. To ensure expedited processing of the said bill by the House, the republished bill is not to contain any matters outside the impugned Act. 2, that in respect to the amendments made to sections 3 and 4 of the Kenya Medical Supplies Authority Act as contained in the Health Laws Amendment Act number 5 of 2019, the Departmental Committee on Health does consider proposing the amendments to the Health Laws Amendment Bill 2021 at the committee stage for consideration by the House. 3, that the bills which after passage by this House and referral to the Senate were stopped from proceeding at the Senate be resent to the Senate for its consideration and decision in light of the interim orders given by the Appellate Court on 2nd February 2021 and the final orders given on the 19th of November 2021. This includes the Kenya National Library Service Bill 2020, Parliamentary Pensions Amendment number 3 Bill 2019, the Public Service Values and Principles Amendment Bill 2019, the Cancer Prevention and Control Amendment Bill 2020, and the National Youth Council Amendment Bill 2019. 4, that as part of the ongoing end-term review of the standing orders, the Procedure and House Rules Committee undertakes a review of standing orders number 121 and 143 with a view to aligning the provisions with the Constitution as guided by the appellate courts. In the meantime, we will be guided by the text of the judgment of the appellate courts. Number 5, that with respect to the orders of the Court of Appeal regarding the cross petition number 284 of 2019 by the National Assembly, in which the National Assembly sought about 16 declaratory orders against the Senate, I will be giving direction to the Clerk of the National Assembly and our Council on how to proceed to implement the order of the Court of Appeal. The House is accordingly informed and guided. I thank you, members. What's the point of order? Honorable. Yeah.
Mr. Speaker, I really want to thank the Court of Appeal, the Speaker's office, the Clerk's office, because, Mr. Speaker, out of the 21 statutes out of the 23 which were challenged by the Speaker, 21 the Court of Appeal has confirmed to be constitutional. Mr. Speaker, all those 23 had my signature as the leader of majority. In fact, the Senate challenged only the government bills. And Mr. Speaker, for 7.5 years I was the leader of majority under your leadership and the clerk. We were arguing and saying that the Constitution of Kenya 2010 was very explicit on the roles of a bicameral parliament, Mr. Speaker. That, Mr. Speaker, the Constitution of Kenya had given the Senate very limited mandate. And this judgment, Mr. Speaker, of the Court of Appeal is very clear, and it has placed the Senate in its place within the reading of the Constitution. But, Mr. Speaker, if you read the legislative powers from Article 109 all the way to Article 114, it is very clear, crystal clear. Day and night, the drafters of our Constitution knew what they were saying. And that's why, Mr. Speaker, today we can say that the Senate never again will they encroach on the National Assembly mandate. Mr. Speaker, it is very clear, and you have said it a number of times, that the Constitution said any bill can originate, a member of parliament can originate any bill in the bicameral parliament. The function of budgetary and taxation and the finance bill was exclusively an appropriation bill for the National Assembly. The vetting of public and state officers, it is very clear, Mr. Speaker, in the Constitution. And Mr. Speaker, you have seen it over and over again that there are committees of this House mandated by the Constitution, not even the standing orders, that are being duplicated in the Senate. Speaker, the people of Kenya, and I have nothing against the Senate. In fact, in 2011, in the 11th Parliament, we said even the leadership of this country, they knew the reason. Those who came to the National Assembly, they knew why they were coming to the National Assembly. They knew the powers of the National Assembly. And those who went to the Senate, and you know the first Senate, Mr. Speaker, was more like a house of old men. That's why you saw the Professor Anyang' Nyong'o, the Kiraitu Murungi, the Yusuf Haji, the late Yusuf Haji. You know, those are the pioneers of the Senate. Now, the young, energetic members who went to the Senate realized, you know, Senator Hassan Omar, Boni Khalwale, they realized that this House has no mandate, has no powers. So, Mr. Speaker, the Constitution is very, very clear. Mr. Speaker, the other issue which we did, which was very important, Honorable Badi now will agree with me, for 7 years, we were dealing with this matter of the cross petition, whether the officers of leadership was provided for in the Constitution, the leadership in the Senate. And the Speaker, I hope the Auditor General is watching this issue, that the leader of majority and the leader of minority is provided for in Article 108. Ideally, the leader of minority in this House is supposed to be in charge of his numbers, the minority side in the Senate. And Honorable Kimunya is supposed to be the leader of majority in both houses. So, Speaker, that is what the Constitution says. So, Mr. Speaker, what happened? What happened? People decided to use the Senate standing orders. And based on this, I really want to say that the High Court, this matter was very good, Mr. Speaker. We asked the Attorney General of the Republic of Kenya, the Attorney General Emeritus, Professor Gidi Mugai, and the current one, please, can government, because we saw ministers, Minister for Interior, Minister for Foreign Affairs, appearing in the Senate. So we asked the Attorney General, can you initiate? But Mr. Speaker, this cross petition by the National Assembly concerning the establishment of these offices, we need to pursue it. We need to pursue it, and those leaders who occupy those offices, past and present, must be surcharged for all the monies. The Auditor General must surcharge them. Mr. Speaker, the ball is in you. If you choose the Senate, you choose a House. It's not like the Senate of the US. So, Mr. Speaker, this is a momentous day. Article 110(3) is very clear. And Mr. Speaker, now you must use your powers. You only decide where the question arises. Yeah, bills of this House should not just go to the Senate. A decision now will be by the Speaker. I beg to ask you, Mr. Speaker, finally, last week I asked you on the Article 132, the President's address, which is very important constitutional day.
No, we've addressed the issue. We've addressed that. Yeah, we have addressed. The earlier communication was about announcing that decision, but we are still waiting for the technical advice. So far they have said we maintain the numbers, but we'll be able to observe social distance. Honorable Wamalo.
Mr. Speaker, it is indeed true. It's a win-win for both houses. And as you clearly put it, Mr. Speaker, the question you should be asking, how much is Wanjiko losing? Mr. Speaker, I want to salute the distinguished judges for the wonderful direction they've given, Mr. Speaker. I know these both houses have been together, and I sympathize with you, Mr. Speaker. I remember even the last Parliament, on matters of the division of revenue, which Honorable Badi argued very well on the floor of this House. You know how much it costed when they went to court on that matter, Mr. Speaker. And it's my prayer that from now henceforth, Mr. Speaker, the Senate should be given a copy of this decision. And it will be nice, Mr. Speaker, for them to also look at it and on the floor of the House so that they can also comment on it. Because we want to move together, Mr. Speaker, as one family. And the siblings rivalry, Mr. Speaker, we've been having, actually, Mr. Speaker, it was uncalled for. Because when you read the Constitution, Mr. Speaker, it's very clear. The Senate participates. It is this House that enacts laws. And from that determination, Mr. Speaker, it shows clearly that the National Assembly is an upper house, Mr. Speaker. It goes without saying. From today henceforth, I think the rivalry, sibling rivalry that has been there, it must come to an end so that they accept that they are the lower house and we move together as a family. But Mr. Speaker, they continue participating. On the issue of the leadership, it is true this matter has been there. And Honorable Badi has mentioned it very clearly. And I think in Article 226, anybody maybe has consumed the money, they should be surcharged. That money should be paid back, Mr. Speaker. Mr. Speaker, people cannot continue bashing this other house and yet they didn't follow the Constitution. And when you look at the people...
Honorable Kiano.
Thank you, Mr. Chairman. Mr. Speaker, in effect, although the circumstances call for celebration, I think what should come uppermost in our mind is the goodwill. We should invoke goodwill and magnanimity in the winning, so that we approach the other house in a way that they will feel reasonably subdued in a way that is not punitive. Because I think just like the Bible, our Bible tells us that litigation all the time is not solution to matters. Equally, Mr. Speaker, we have there is a matter that is not touched, that was remitted back to the High Court. That matter concerns the conflict between the committees. Recently, Mr. Speaker, we have one occasion where the Chief Justice refused to appear before the Senate on the basis that these matters had already been decided and deliberated on by my committee in the National Assembly. So this is a very urgent matter that the conflict now, apparent committee conflict appearing between the committees, should be resolved. So the hearing in the appeal, I think the ranking member was instrumental.
Honorable Undo.
Honorable Speaker, thank you for this opportunity. I think I want to go on record that indeed, since I came here, I have literally wondered, what is the role of Senate? I had an opportunity to read the Constitution, and my understanding was very clear. They were supposed to participate in lawmaking in strictly matters relating to the counties, where they got the audacity to believe they can actually deal with all matters in this country was something that has always baffled me for so long as I've always been here. Many occasions when we have had meetings with them, it has always ended up in such a acrimonious manner. Honorable Speaker, I remember went for the mediation in the Land Use and Fiscal Planning Act, plus the one for evaluating. And Honorable Speaker, it was such a show that actually ashamed me to the level of misunderstanding of the role and context what Senate needs to do. Honorable Speaker, I think the remaining issue here is the cross petition. We must settle this matter as soon as possible so that we avoid duplication of roles, wastage of time, and wastage of public resources. I wonder what role the Senate has to summon the director or IG. What role the Senate has to deal with foreign affairs issues? Honorable Speaker, we need to conclude this matter for the benefit of the people of Kenya. It's not about you, it's not about us, but it's about the people of Kenya. Thank you, Honorable Speaker.
Member for Tharaka.
Thank you very much, Mr. Speaker. Mr. Speaker, let me begin by saying that this is one of the best decisions that the Court of Appeal has produced this year. The first one was actually the BBI, and this is the second one. Number two, this decision would actually go into our universities where our children, using the principle of stare decisis, use that decision for purposes of scholarship. Thirdly, the Senate has actually, and they should understand its place, that in as far as matters national are concerned, this is a preserve of this House. Mr. Speaker, allow me to wave into the cross appeal, which now becomes a substantive suit in the High Court. First and foremost, I commend you, Mr. Speaker, because you've been asking what roles these Senate officers are doing when actually the Constitution is silent on them. Therefore, the High Court should actually stretch its mind to interpret what we are asking them to do and make those declarations. Anybody who is in the Senate and has earned money, strictly speaking, unconstitutionally and illegally, has only one remedy upon himself or herself. It's a surcharge by the government, and the money should actually be refunded or recovered. Thank you.
Member for Kisumu Town West.
Thank you, Mr. Speaker. Mr. Speaker, thank you very much for not just highlighting the judgment of the Court of Appeal, but analyzing it and dissecting it in a scholarly and lawyerly manner. You made it clear for even non-lawyers in the Senate to understand that judgment clearly. Mr. Speaker, you have been very modest in saying that there's no winner. But I want to tell you, Mr. Speaker, that although the Constitution says that Parliament means the National Assembly and the Senate, out of this House, Kenyans know that Parliament is the National Assembly. There's no other Parliament. They call us MPs, and they call the other House senators. That is a fact. Mr. Speaker, we must commend our legal department. They have done a very good job in coordinating with external lawyers. And I'm proud, many of them were now leading that directorate, were interviewed in the 10th Parliament by myself and others when I was a commissioner. They are doing an exemplary job in the legal department. And this judgment is going to make it clear to the other House that actually they are boxing above their weight. That is a fact they must understand. Mr. Speaker, this judgment is superb in all respects. And I want to tell the House that the judgment you have just dissected gives direction to the High Court so that when the issues they didn't deal with are referred back for reconsideration, they know which direction to take. Mr. Speaker, if there's anybody in the Senate who is imagining that they should take this matter further to the Supreme Court, they'll be wasting public money and judicial time. Mr. Speaker, I stand here feeling very proud about this judgment, and thank you very much for dissecting it for us.
Well, members, just comments. Let's go to business. This one, you also want to weigh in this one?
Yes, Honorable Speaker. And Honorable Speaker, first of all, thank you very much for your guidance. And I know today your guidance is top-notch, and it will be used as reference beyond our borders and even in years to come. Honorable Speaker, and again through your judgment, I've just realized that Senate is just an amorphous political civil society that should be dealing with cattle dips, dam sites, control of rabies in dogs, and markets, Honorable Speaker, on top of lateral revenue allocation formula between the 47 counties, but nothing else more than that, Honorable Speaker. Honorable Speaker, and from this judgment, all the monies that have been used in legal fees should be surcharged in all senators that participated in such matters, Honorable Speaker. Honorable Speaker, imagine recently, I also saw them enjoying themselves in Saudi Arabia, purporting to go and investigate the issue of labor export, which is squarely under the committee of this House on labor and social welfare, Honorable Speaker. Honorable Speaker, and because my chairman is here, I implore upon him, Honorable Speaker, to accept their report as a memorandum
just like any other memorandum from civil societies, any other memorandum from survivors from Saudi Arabia, any other memorandum from recruitment agencies, Honorable Speaker, and then we put into our report, Honorable Speaker, which will be tabled in this House very soon, Honorable Speaker. So, Honorable Speaker, thank you for your guidance. You are always a mobile encyclopedia when it comes to the legal matters, Honorable Speaker, and we do support your presidential bind in 2022. Thank you very much, Honorable Speaker.
Member for Nyando.
I thank you very much, Honorable Speaker. Listening to cartoon in the name of Lesan Kok, you are left baffled. But Honorable Speaker, thank you for that quite elaborate and in-depth analysis of the court findings. Honorable Speaker, I've always believed that if senators really wanted to be serious, there's a lot of work to be done.
There's an intervention by the Honorable Olagwa Luoch.
The Speaker, as much as Honorable Okello may not agree with Honorable Sankori, is it not to call him a cartoon?
Did you call Honorable Okello, did you call Honorable Sankok a cartoon?
Yes, I did, and he didn't have any problem with that, because indeed he is. But Honorable Speaker, if we are to make progress, there is a lot of work on the ground for senators to do.
Now he's complaining.
Now he's complaining. All right, I withdraw. Yes. He is my friend. He's my friend. So, Honorable Speaker, I have seen many cases when ministers or cabinet secretaries still present themselves before the Senate, even on matters that are under investigation and live in this House. Last week, the CS for Sports appeared before the Senate. And from my recollection, sports wasn't devolved down to the counties. So we need to really give, as this judgment has done, a very proper analysis of what they need to be doing for our counties there. But Honorable Speaker, some of which have been alluded to by my friend Honorable Sankok. You know, you talk about sanitization on the ground, you talk about clearing dogs with rabies, and many things that they should keep themselves busy doing, unless they are saying that they quickly sanitize.
Now, no, members, let's proceed now with business. There is need to sanitize many places. Next order.
Order number 4, petitions. Order number 5, papers.
Leader majority.
Thank you, Honorable Speaker. I beg to lay the following papers on the table of the House today, Tuesday, November 23rd, 2021. And one is the reports of the Auditor General and financial statements in respect to the following institutions for the year ended 30th of June, 2021, and the certificates therein. A, the Horn of Africa Gateway Development Project by the State Department for Transport, the Ethics and Anti-Corruption Commission, Staff House Mortgage and Car Loan Scheme, and Ethics and Anti-Corruption Commission. Number 2, the reports of the Auditor General and financial statements in respect to the following institutions for the year ended 30th of June 2020 and the certificates therein. One, the National Authority for Campaign Against Alcohol and Drug Abuse, the Kenya Universities and College Central Placement Service, the Technical University of Kenya, the Kenya Education Management Institute, the National Environment Trust Fund, non-government organizations, NGOs Coordination Board, and the National Transport and Safety Authority. Number 3, the reports of the Auditor General and financial statements in respect to the following constituencies for the year ended 30th of June 2020 and the certificates therein. And the constituencies are Ganze, Madera, Ainabkoi, and Kisauni. Number 4, the reports of the Auditor General and financial statements in respect to the following constituencies for the year ended 30th of June 2019 and the certificates therein, and this being Kigumo and Odaya. Number 5, the reports of the Auditor General and financial statements for the Kenya Wildlife Service for the year ended 30th of June 2019 and the certificates therein. Thank you, Honorable Speaker.
The Vice Chair, Budget and Appropriations Committee. Was that Honorable Shinali?
Thank you, Speaker. Honorable Speaker, I beg to lay the following paper on the table of the House today, Tuesday, November 23rd, 2021. Report of the Budget and Appropriations Committee on its consideration on the County Government's Grants Bill, Senate Bill number 35 of 2021.
The Vice Chairperson, Departmental Committee on Administration and National Security.
Thank you, Honorable Speaker. I beg to lay the following papers on the table of the House today, Tuesday, November 23rd, 2021. Report of the Departmental Committee on Administration and National Security on its consideration of the public petition regarding gazettement of Kitui as hardship area, 2, public petition regarding accessing national identity cards by the Nubian community, and 3, fact-finding reports regarding forceful eviction of the resident of Nduguini, Makima, ward of Mbere South constituency.
Vice Chair, Trade, Industry and Cooperatives Committee.
Thank you, Mr. Speaker. I beg to lay the following paper on the table of the House today, Tuesday, November 23rd, 2021. Report of the Departmental Committee on Trade, Industry and Cooperatives on its consideration of the Kenya Industrial Research and Development Institute Bill, National Assembly Bill number 44 of 2020. Thank you.
Finally, the Chairperson, Departmental Committee on Finance and National Planning.
Thank you, Honorable Speaker. Honorable Speaker, I beg to lay the following papers on the table of the House today, Tuesday, November 23rd, 2021. Reports of the Departmental Committee on Finance and National Planning on its consideration of the Senate amendments to the Public-Private Partnerships Bill, National Assembly Bill number 6 of 2021. The Asian Widows and Orphans Pensions Repeal Bill, National Assembly Bill number 29 of 2021, the Provident Fund Repeal Bill 2021, National Assembly Bill number 30 of 2021, the Public Procurement and Asset Disposal Amendment Bill 2021, National Assembly Bill number 32 of 2021, the Public Procurement and Asset Disposal Amendment number 2, National Assembly Bill number 36 of 2021. I thank you, Honorable Speaker.
All right, next order.
Order number 6, notices of motion.
Honorable Fatuma Gedi.
Thank you, Mr. Speaker. I beg to give notice of the following motion that this House adopts the report of the Departmental Committee on Administration and National Security regarding forceful eviction of the resident of Nduguini, Makima, ward of Mbere South constituency, laid on the table of this House Tuesday, November 23rd, 2021. Thank you, Mr. Speaker.
Next order.
Order number 7, questions and statements.
First question by the member for Kajiado North, Honorable Manje.
Thank you, Speaker. My question is question 449 of 2021 to the Cabinet Secretary for Health. Could the Cabinet Secretary explain the whereabouts of an infant who had been abandoned, later rescued on 5th October 2021 in Ongatarongai area, Kajiado County, and taken to Nairobi Women Hospital, Ongatarongai branch in the same town for medical treatment, but later reported missing from the hospital a few days thereafter? What measures does the ministry have to ensure that medical institutions and facilities are able to account for unidentified persons who are taken in for treatment?
Question will be replied to before the Departmental Committee on Health. Next question by the member for Tharaka, Honorable Murugara.
Thank you. Thank you, Mr. Speaker. Allow me to ask question number 473 of 2021, directed to the Cabinet Secretary for Education. Number one, could the Cabinet Secretary explain why Mr. Kamui Joshua Munene, TSC number 505757, Mr. Muteria Aaron Mutugi, TSC number 480686, Mr. Jafet Kirimi Mudhwe, TSC number 535767, Ms. Ellen K. Njagi, TSC number 392191, Ms. Nyaga Priscilla Kagendo, TSC number 366144, Mr. Peter Ntoiti Ngochi, TSC number 508176, Ms. Rose Katweri Njeru, TSC number 423450, and Ms. Purity N. Gideon, TSC number 345212, who were appointed as senior teachers in the year 2017, are yet to be issued with appointment letters as required under Teacher Service Commission's policy on human resource. Number two, could the Cabinet Secretary state the timelines within which their respective appointment letters shall be released to them? Thank you, Mr. Speaker.
Question will be replied to before the Departmental Committee on Education and Research. Next question by the member for Meru County, the Honorable Bishop Kawira Mwangaza.
Thank you, Honorable Speaker. My question is 476 of 2021 to the Cabinet Secretary for Labor, Social Security and Services. Number one, could the Cabinet Secretary explain the process of implementation and disbursement of the Inua Jamii Cash Transfer Program in Meru County? Number two, could the Cabinet Secretary provide an updated list of the beneficiaries of the program in Meru County and also state the eligibility criteria to enable potential applicants to submit the application details? Number three, what measures has the ministry put in place to ensure timely disbursement of funds to the beneficiaries of this program in Meru County? Thank you, Honorable Speaker.
Question will be replied to before the Departmental Committee on Labor and Social Welfare. Last question by the member for Wudanyi, the Honorable Danson Mwashako Mwakuoma.
Thank you, Honorable Speaker. I raise to ask a question number 489 of 2021 to the Cabinet Secretary for ICT, Innovation and Youth Affairs. Could the Cabinet Secretary provide names of all farms which own communication masts and installations at the Vuria Hill in Wundanyi constituency? Could the Cabinet Secretary explain why the road leading to the said installations have not been maintained and why the owners of the masts have failed to carry out the corporate social responsibility projects for the community living in the area, particularly in Mugange, Mwanda area? Considering that the masts and installations have occupied and disenfranchised the community of a recreational site and a viable area for tourism purposes. Could the Cabinet Secretary clarify whether any environmental impact assessment on the health and safety of Kenyans living near the masts and installed equipments was carried out, particularly on the effects and nature of the network and waves transmission before installations of the masts? And if yes, provide a copy. Could the Cabinet Secretary consider employing technicians from amongst the locals for jobs such as routine maintenance of the masts and equipments and tending of the surrounding environment and pathways leading to the said installations? Thank you, Honorable Speaker.
The question will be replied to before the Departmental Committee on Communication, Information and Innovation. Next segment, request for statement, and there's one from the member for Dagoretti South.
Thank you very much, Mr. Speaker, and I do rise to request for a statement regarding incomplete and substandard roadworks in Dagoretti South constituency. Honorable Speaker, pursuant to Standing Order number 442C, I wish to request for a statement from the chairperson of the Departmental Committee on Transport, Public Works and Housing regarding incomplete road projects and substandard workmanship in road construction in the Dagoretti South constituency. Mr. Speaker, in the year 2019, the Ministry of Transport, Infrastructure, Housing and Urban Development and Public Works initiated a project of the construction and rehabilitation of up to 400 kilometers of road, mainly in the foremost settlement areas in Nairobi City County. The plan, as announced, was intended to upgrade the roads to cabro and bitumen standards. The cabro roads were to benefit the densely populated areas, mostly in the informal settlement areas in the Dagoretti South constituency, and particularly Reruta, Waithaka, and Gando. Honorable Speaker, the construction of the said roads project commenced in January 2020. However, the contractors have ignored some of the basic engineering principles in the construction of these roads, such as the standard width of a road, the drainage system, the ground preparation, the quality of the construction materials, and the coordination between the contractor, the forepersons, and the implementing agency, amongst other issues. Honorable Speaker, now concerned that this program is about to be concluded, works in most of the major roads prioritized for the upgrade are yet to commence. A case in point, Mr. Speaker, is Mbereri Road, that was prioritized as road number 2 in the priority list work plan, and which to date remains unattended to, even after the demolition and relocation of structures and utility installations to pave way for the road construction were carried out. Other major roads prioritized include Wambiri Road, Jerusalem Road, and Wairimo Road, among many others, which have since been abandoned. Honorable Speaker, it is against this background that I seek a statement from the chairperson of the Departmental Committee on Transport, Public Works and Housing on the following. 1, Mr. Speaker, could the chairperson provide the status of the roads project in the Dagoretti South constituency, which were prioritized in this program by the Ministry for upgrade to bitumen or cabro standards? 2, what are the timelines for the completion of the said roads project? And 3, Mr. Speaker, what measures are in place to ensure the quality of these roads that are being constructed? Mr. Speaker, I do profusely thank you. I signed these on the 17th of November 2021. Thank you very much, Mr. Speaker.
Chairperson. Vice Chair. Request will be channeled through the Office of the Leader of Majority. Next order.
Order number 8, the Radiographers Bill, National Assembly Bill number 47 of 2019, second reading. Question to be put.
Honourable members, debate on this motion was concluded, and what remained was a question to be put, which I hereby do. The radiographers, I put a question that the Radiographers Bill, National Assembly Bill number 47 of 2019, be now read a second time. Will as many as that opinion say aye? Aye. As many as contrary opinion say nay? The ayes have it.
A bill for an act of parliament to make provisions for the training, registration, and licensing of radiographers, to regulate their practice, to provide for the establishment, powers, and functions of the Radiographers Board of Kenya, and for connected purposes. Order number 9, motion, report on a public petition by residents of Wajir and Garissa counties regarding lack of access to citizen registration services.
Members, again, debate on this motion was concluded. I therefore put the question, which is that this House adopts a report of the Departmental Committee on Administration and National Security on its consideration of a public petition by residents of Wajir and Garissa counties regarding lack of access to citizen registration services laid on the table of the House on Wednesday, August 11th, 2021. Will as many as of that opinion say aye? Aye. As many as of contrary opinion say nay? The ayes have it.
Order number 10, motion. Consideration of Senate amendments to the Public-Private Partnership Bill, National Assembly Bill number 6 of 2021.
Kabisa. Great. Thank you. Thank you. Honorable Duale, what's your intervention about?
No, Chair, I came to the House this afternoon because I was told my statement by Chair for Finance on Kenya Bureau of Statistics will be given to me this afternoon. So if we have passed, then maybe tomorrow I'll be ready. I got an email from the clerk to that committee.
It was ready.
My statement is ready and it will be read by the chair this afternoon.
It was not indicated.
So maybe tomorrow.
Honorable Wanga, will you be able to read the statement?
Yeah. Thank you, Honorable Speaker. The statement is ready, so we can read it tomorrow or on Thursday. Either tomorrow or Thursday.
So which one? Tomorrow afternoon or morning?
Tomorrow afternoon is fine.
Afternoon?
Yes.
Very well. The response will be read tomorrow. So what is leader majority? You are the one.
Thank you, Honorable Speaker. Honorable Speaker, I beg to move that the Senate amendments to the Public-Private Partnerships Bill, National Assembly Bill number 6 of 2021, be now considered. Honorable Speaker, members will be aware that we deliberated on a revamped PPP bill or Public-Private Partnership Bill to bring it into the modern reality and to update what had been considered in this House, taken to the Senate, taken through mediation, but then in the process of all that we discovered there were lots of other things that were not captured, and especially when it comes to issues to do with sorting out the issue of the cost of doing business and removing hurdles and bottlenecks that were entrenched into the previous bills. So the Public-Private Partnership Bill then sailed through this House and found itself into the Senate because obviously it also meant that there will be PPP projects at the county level. And I want to thank the Senate committee because it's taken uncharacteristically a very short time to actually look through this bill, noting that we actually have bills that were referred there in 2018. I think we have about 20 bills that were referred to the Senate and are still at different stages of processing. But on this, the reason to the occasion and proved that with goodwill, in fact, even the 20 could well have been processed. So basically, when the Senate did review, they came up with an amendment to Clause 6. Again, it's just about adding the Principal Secretary in charge of the State Department responsible for matters relating to infrastructure. And on Clause 13, again, they came up with an amendment, basically inserting a time limit of 21 days for the evaluation of a report. Previously, we didn't have that timeline. In Clause 75, the Senate did do some tinkering here and there to basically editorially make it better, and we agree with that. So basically, I think what they've done is they've enriched the bill. They have looked at the amendments and going by our earlier discussion and the court ruling, you actually will be surprised that really there's no amendment that has been brought here that relates to functions of counties or the counties or county government. But be that as may, I think they've still gone ahead and improved on the bill. We've had discussions with the Treasury, and I'm sure the committee will confirm, and we can live with these amendments rather than go through a to and from situation, which will then lead to mediation, and we don't have the luxury of that time. So I want to implore members that we take it, that we thank the Senate for enriching our bill, for that whatever they've done can only be better for the bill. There's nothing unbecoming, there's nothing controversial, and hence I would wish to urge the House that we accept in total the amendment by the Senate so that we can move to the Committee of the Whole House and give life to this process of public-private partnerships. I don't want to go through the background of why we needed PPPs, because this House deliberated on this bill and was conscious of why they were passing it. But the only thing that has been added is really the issues that have been brought by the Senate as part of enrichment of this bill. Honourable Speaker, I really don't want to take time on a very straightforward matter. I want to implore the House that we team up together, we pass this bill so that come next week we have the best Christmas gift for future investors, for our infrastructure sector, is that we now have a modern public-private partnership bill, which will then be enacted, that will sort out our contractual obligations and contractual issues into the future, so that by the time we are looking at the next, expressway, by the time we're looking at the Mau Summit Expressway, when we're looking at all those other PPPs, at all those, at least now we have a law that we can refer to and see that everything is done in accordance with the will of this House. Mr. Speaker, with those words, I beg to move, and I ask the Honorable Gladys Wanga, the Chair of Finance and Planning, to second.
Honorable Wanga.
Honorable Speaker, I beg to second, and as has been mentioned by the Leader of Majority, essentially the amendments that have been made by the Senate are not fundamentally altering what the National Assembly had considered. In some instances, they've just brought in detail that's making the bill better. So, Honorable Speaker, as a committee, we did not see the need to disagree or go into mediation. While some we did not necessarily agree with, but they were not fundamental in nature to necessitate mediation. So, Honorable Speaker, with those few remarks, I beg to second.
Members, I propose a question, which is that the Senate amendments to the Public-Private Partnership Bill, National Assembly Bill number 6 of 2021, be now considered. The Honorable Undo.
Honorable Speaker, I think I sat here as we debated plus the Committee of the Whole House. PPE is the way to go, because increasingly the government is not going to have funds to undertake anything. But probably the most important, that by accepting all the amendments that are proposed, we are sending a very clear message to Senate that we are not interested in sibling rivalry. What is good for Kenya is good for Kenya, and I want to implore members that let us pass those amendments, because we have so many pending projects in the pipeline that requires to be funded. This Kenya has to develop, and we have to develop in a hurry. We have no luxury of time. With those few remarks, Honorable Speaker, I support.
Honorable Wamalwa. Honorable Sakwa Bunyasi.
Mr. Speaker, this is in respect to the earlier process. I was going to request the Chair for Finance to confirm when she will table the public debt bill. She said she would almost read it, so it's not on this. Thank you.
Honorable Sotsi, on this one.
Mr. Speaker, I think I want to contribute to the next item.
Okay.
Not this one.
Honorable Wangwe. Honorable, I'm just following the request. Honorable Lesonet.
Thank you, Mr. Speaker, for this opportunity. Mr. Speaker, this bill, we need it like yesterday, Mr. Speaker, so that private sector can commit resources towards large investments and large projects, Mr. Speaker, and especially projects, Mr. Speaker, that have a way of raising its own money. And it is the reason, Mr. Speaker, that I stand here today to support. And Mr. Speaker, and as we do that, we also need to encourage the county governments, Mr. Speaker, that for them to be able to give out and have first-class facilities, specifically in medical, large water projects, Mr. Speaker, roads at the counties which make commercial sense, they need to go this way, Mr. Speaker, this way of public-private partnership, so that they don't just rely on the equitable share or on funding from national government for them to do projects that will impact on lives now. Mr. Speaker, this would also enable the government, the national government, and equally the county governments to channel resources which would otherwise have gone into large projects to social projects, Mr. Speaker. Projects which are of social nature, they make no commercial sense. And Mr. Speaker, with those very few remarks, I support, Mr. Speaker, this amendment. I thank you, Mr. Speaker.
Well, if the members who are they could I take it that there are no more contributions. Maybe now, since there's nobody else who has made a request, move her to reply. Honorable Kimunya.
Honorable Speaker, I really want to thank members for their brief contribution to this bill, and it shows the depth of interaction and interrogation of the original bill when it was in this House, and the faith they have in us convincing them that we are happy with what the Senate has done. So I want to thank members, and once again also to thank the Senate for the speedy consideration of this bill, and ask them to also speedily process the other bills that are in the Senate, so that we can close the year with all the work that's been done by the National Assembly turning into law, and hopefully all the work that's been done by the Senate also turning into law before we are back for the next session. With those few remarks, I reply.
Fellow honour members, so we are still proceeding to the next stage of the bill. I therefore put the question, which is that the Senate amendments to the Public-Private Partnership Bill, National Assembly Bill number 6 of 2021, be now considered. Will as many as that opinion say aye? Aye. As many as contrary opinion say nay? The ayes have it. Next order.
Order number 11, Committee of the Whole House.
Honorable members, we are now in committee of the whole House to consider number 1, Senate amendments to the Public-Private Partnerships Bill, National Assembly Bill number 6 of 2021. There are not too many. Yes, just hold on for a minute. We just put a table here in order. We are ready. Okay, so we will start.
Senate amendment to clause 6.
I propose the question that the Senate amendments to clause 6 be now approved. Chair?
Thank you, Honorable Chair. Should I say that it should be approved?
Chair, you have to seek approval and explain why it should be approved.
Okay.
Yes.
Thank you, Honorable Chair. Chair, I beg to move that Senate amendment to clause 6 be approved by the House. Essentially, we had made a proposal or an amendment to remove the principal secretary serving in the State Department for Infrastructure from the membership of the committee, the privatization committee. The reason is there are several projects. There could be water, energy, and so on. So we thought these PSs should be added on needs basis. But Senate disagreed and said we should return the one in charge of infrastructure, probably because most PPPs are infrastructure related. So, Honorable Chair, we agree and we beg that it is approved. I beg to move.
To a few members. I see interest from the Honorable Oundo.
Honorable Chair, as much as the amendment looks harmless, and this probably indicates the limited understanding of PPP in generality, because we are going to have very many projects that probably are not fiscal in nature, that are going to be initiated under private-public partnership. But as we have said, in the spirit of accommodating our Senate colleagues, let it go through. But I foresee we might have to amend, because there will be so many other projects in other sectors that require the cooperation. That's why the House had made on a need-to-need basis. But nevertheless, we let it go.
The Honorable Bunyasi.
Thank you, respectfully. I was waiting for this, but I had something small to say on this. I think the experience to date has largely been in the large infrastructure, both transport, but also water, for example. So I guess it's in energy. So I guess that it's in that spirit that this is going forward. I also think we should go with it.
Honorable members, I now put the question that the Senate amendment to clause 6 be now approved. Will as many of that opinion say aye? Aye. Will as many of our counter opinion say nay? The ayes have it.
Senate amendment to clause 33.
I propose the question that the Senate amendment to clause 33 be now approved. Chair?
Thank you, Honourable Chair. Honourable Chair, I beg to move that Senate amendment to clause 33 be approved by the House. And the Senate there is just adding a timeline within which the evaluation report should be produced. So if you bring your proposal for a PPP, they are saying that it should be done within 21 days. It should be considered within 21 days, which we had not done earlier. So I think this is a useful addition. I beg to move.
Honourable members, I propose the question that the Senate amendments to clause 33 be now approved as moved by the chair. I see interest from the Honourable Shamala.
Thank you, Chair. I do really want to support this amendment. I think it's important that in an area and a sphere so big of public-private partnerships that we do have timelines with regards, and more specifically to this amendment. It seals all loopholes of trying to curry favor and maybe delays which may lead to corruption. So with those few remarks, I support.
The Honourable Ounda, you still have something to this? Very well. I then now put the question that the Senate amendments to clause 33 be now approved. Will as many of that opinion say aye? Will as many of a contrary opinion say nay? The ayes have it.
Senate amendment to clause 75.
I propose the question that the Senate amendments to clause 75 be now approved. Chair?
Thank you, Honourable Chair. I beg to move that the Senate amendments to clause 75 be approved by the House. And this amendment, Honourable the Chair, is to reduce the number of people appointed by the Cabinet Secretary from 5 to 4, and then increase the number of people coming from the Council of Governors from 1 to 2. So that's the gist of the amendment. So the Cabinet Secretary is supposed to appoint 5 people to the Appeals Committee, and so we are reducing them to 4. And then the Council of Governors is supposed to appoint 1. They're increasing it to 2. So we agreed with the Senate on that. And also the part B is if you are aggrieved with the decision of the committee, the Senate is providing that within 7 days of the decision, you can make an application for review. So I beg to move, Honourable Chair.
I now propose the question that the Senate amendments to clause 75 be approved as moved by the chair. I now put the question that the Senate amendments to clause 75 be now approved. Will as many as that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it.
New clauses. New clause 75A.
Chair, you should now move for second reading of this new clause.
Thank you, Honourable Chair. I beg to move that new clause 75A from the Senate be now read a second time. Essentially, here, the Senate is introducing this appeals committee, so that if the PPP committee, the projects committee of the PPP does not approve your project, or you feel aggrieved, then you have a place where you can complain, and they are setting out that the CS shall designate a public officer to serve as secretary to the committee. The person shall be an advocate of the High Court with at least 7 years standing. The remuneration shall be determined by the SRC. We do A only, not B. We do one at a time.
It is one at a time.
Okay, so I'll do A, which is the designation of the cabinet secretary appointing the secretary. I beg to move that this 75A be now read a second time.
I propose the question that new clause 75A be now read a second time. I see interest from the Honorable Wangwe.
Thank you, Chair. Chair, I wish to support the amendment, the new clause by the Chair, especially reading 75A together with 75A1 together with 2. Honorable Chair, it's important that a secretary be designated, and in any setup, Honorable Chair, like this one, if the secretary shall have a standing of a capacity of an advocate of the High Court, especially with 7 years standing, then that would be a good suggestion, Chair. Therefore, I support.
Honorable members, I now put the question that new clause 75A be now read a second time. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it. Chair? Just hold on. Just hold on, Chair. Yes, it is my part. I now propose the question that new clause 75A be part of the bill. I now put the question that new clause 75A be part of the bill. Will as many of that opinion say aye? Aye. Will as many of the contrary opinion say nay? The ayes have it.
New clause 75B.
Chair.
Thank you, Honorable Chair. I beg to move that new clause 75B by the Senate be now read a second time, and this is just outlining that the members of the committee shall be paid salaries and allowances as the cabinet secretary shall, in consultation with the Salaries and Remuneration Committee, determine. I beg to move.
I propose the question that new clause 75B be now read a second time. I put the question that new clause 75B be now read a second time. Will as many of that opinion say aye? Aye. Will as many as of a contrary opinion say nay? The ayes have it. I now propose the question that new clause 75B be part of the bill. I put the question that new clause 75B be part of the bill. Will as many of that opinion say aye? Aye. Will as many as of a contrary opinion say nay? The ayes have it.
New clause 75C.
Chair.
Thank you, Honorable Chair. I beg to move that new clause 75C from the Senate be now read a second time. And this speaks to the issue of conflict of interest. That if you're a member of the committee and you have direct or indirect interest on a matter, then you should recuse yourself and declare your interest and recuse yourself. I beg to move, Honorable Speaker. Chair.
I propose the question that new clause 75C be now read a second time. I put the question that new clause 75C be now read a second time. Will as many of that opinion say aye? Aye. Will as many of that opinion say nay? The ayes have it. I now propose the question that new clause 75C be part of the bill. I now put the question that new clause 75C be part of the bill. Will as many of that opinion say aye? Aye. Will as many of our contrary opinion say nay? The ayes have it.
New clause 75D.
Chair?
Thank you, Honorable Chair. I beg to move that new clause 75D, 1 and 2 from the Senate be now read a second time. And new clause 75D1 speaks to the offenses that a person shall not commit in dealing with a committee. So failing to provide information required without justification, fail to provide information within reasonable time, submitting false or misleading information, misrepresenting or knowingly misleading a member of the committee, or interfering with or exerting undue influence on any member of the committee. Those shall constitute offenses. And 2 speaks to what kind of penalty those offenses shall attract. And it will be a fine not exceeding 500,000 or imprisonment for a term not exceeding 1 year or to both. I beg to move, Honorable Chair.
I propose the question that new clause 75D be now read a second time. I see interest from the Honorable Undo.
Chair, it is a good amendment, but I'm just curious, we probably need a further explanation. Why would matters that will fall under the penal code be included here? Things like assault, threatening, obstructing, those kind of things, Honorable Chair, are already adequately covered in the penal code, and I would really have imagined members of the Senate would have known that very clear. But nevertheless, I find probably the Chair could further explain why that was sustained, knowing that very well this is a matter already covered in the penal code. Thank you.
I see no other interest in this. I therefore now propose the question that new clause 75D be now read a second time. I then put the question that new clause 75D be now read a second time. Will as many of that opinion say aye? Will as many of our contrary opinion say nay? The ayes have it. I propose the question that new clause 75D be part of the bill. The Honorable Shamala, you have an interest in this? Very well. I then proceed to put the question that new clause 75D be part of the bill. Will as many of that opinion say aye? Will as many as our opinion say nay? The ayes have it. But Chair, I was just wondering on this one, this new 75D that we have just passed, where we are saying without a reasonable cause or a lawful excuse to obstruct or hinder, assault or threaten. Can somebody have a lawful cause to assault or to threaten? But this is the law that we have made. We will move on.
New clause 75E.
Chair.
Thank you, Honorable Chair. I beg to move that new clause 75E by the Senate be now read a second time. And this is just stating that the decree of the committee shall issue its decree, and the decree shall be enforceable in the same manner as the decree of the court. Honorable Chair, on the issue that you're raising, as I said when I was seconding the bill, we did not necessarily absolutely agree with every point the Senate made. But now we just looked at whether these were fundamental enough to result in mediation. That's why we allowed some of the points to pass. That was the main consideration of the committee. Since a big part of the bill, this is a very, very big bill, It has some really fundamental issues. A big part of it was well done by this National Assembly. So we decided that this should not constitute sufficient grounds for mediation. So I will urge Honorable Undo to just bear with us and yourself, Honorable Chair, on these matters. Because if they were in our hands fully, we would have probably dealt with them here once and for all. I thank you, Honorable Chair. And I beg to move.
Very well, Chair. I now put the question that the Senate amendment. Yes, hold on. I'll have a retake on that. I then propose the question that new clause 75E be now read a second time. The Honorable Wangwe.
Thank you very much, Honorable Chair. Honorable Chair, I wish to support this proposed new clause by the Chair. However, I'm a bit reluctant, although in the line that the Chair has said, because I'm very much aware that it's only the Constitution that can give powers to either a place or any organization to set up an equivalent of a court. For instance, Article 125, which makes a committee of the House to have the same powers as those of the High Court of Kenya. Therefore, Honorable Chair, in as much as we support this, in line of what the Chair Finance has said, it's important we put our views so that in future, let our voices be recorded. Thank you, Honorable Chair, and I support.
The Honorable Oundo.
Chair, again, I join my colleague, the Majority Whip, in really raising concerns on the text and the wording of that particular 75E. I'm not so sure whether the committee, and I need to be appraised because it has been of time, whether the committee is a tribunal to the sense that has got powers of a court of law. If it doesn't, then obviously that amendment is just superfluous and will have no value at all, or it will be just struck out by any court, because a committee cannot have the power of a court. Probably something I'm not so sure if they sought adequate legal advice, or we just say in the sake for avoiding prolonged mediation, let's just, as we say, probably we used to say in computer, garbage in, garbage out. So probably the chair could explain again so that we understand.
I see no further interest. I therefore now put the question. I put the question that new clause 75E be part of the bill. Will as many of that opinion say aye? Will as many of the opinion say nay? The ayes have it. But we have done it, Chair. But I hear the Honorable Undo and my brother, the Honorable Wangwe, and of course myself and the Honorable Bunyasi is shaking his head, wondering which court this committee will be equating itself to. Is it the High Court? Is it a tribunal? Is it the Supreme Court? Is it what court? But it is the law that we have made. We have made progress. So, honorable members, I direct that now we consider the perpetuities Yes, we have put the questions on each. Yes, we have completed the consideration of the Senate amendments to the Public-Private Partnerships Bill. So it's done. We on 75 we did it on each part. So we have completed it. So we shall now move to the perpetuities and accumulations amendment bill, National Assembly Bill number 24 of 2021.
Clause 2.
I propose the question that clause 2 be part of the bill. There's no amendment to it. I therefore now put the question that clause 2 be part of the bill. Will as many of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
Clause 3.
I propose the question that clause 3 be part of the bill. Chair, you have a proposal on this.
Thank you, Honorable Chair. Honorable Chair, I beg to move that clause 3 of the Perpetuities and Accumulations Amendment Bill, National Assembly Bill number 24, 2021 be amended as per the order paper. And this is just to provide that any income of the trust that is not accumulated should be distributed. Honorable Chair, the income shall be distributed to the intended beneficiaries. That's the amendment, Honorable Chair. I beg to move.
Honorable members, I propose the question that clause 3 be amended as proposed by the chair. I then put the question that clause 3 be amended as proposed by the chair. Will as many of that opinion say aye? Aye. Will as many of the contrary opinion say nay? The ayes have it. I now put the question that clause 3 as amended be part of the bill. Will as many of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
Title.
I propose the question that the title be the title of the bill. I now put the question that the title be the title of the bill. Will as many of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it.
Clause 1.
I propose the question that clause 1 be part of the bill. I now put the question that clause 1 be part of the bill. Will as many of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it. Honorable members, we are done with the Perpetuities and Accumulations Amendment Bill. I therefore, we shall now move to reporting. So I will call upon the mover to report on the Senate amendments to the Public-Private Partnerships Bill, National Assembly Bill number 6 of 2021. Mover.
Honorable Chairperson, I beg to move that the committee do report to the House its consideration of the Senate amendments to the Public-Private Partnerships Bill, National Assembly Bill number 6 of 2021, and its approval thereof with amendments.
Honorable members, I put the question, which is that the committee do report to the House its consideration of the Senate amendments to the Public-Private Partnerships Bill, National Assembly Bill number 6 of 2021, and its approval thereof with amendments. Will as many as of that opinion say aye? Aye. Will as many as of a contrary opinion say nay? The ayes have it. We shall move to reporting on the Perpetuities and Accumulations Amendment Bill, National Assembly Bill number 24 of 2021. Mover.
Honorable Chairperson, I beg to move that the committee do report to the House its consideration of the Perpetuities and Accumulations Bill, National Assembly Bill number 24 of 2021, and its approval thereof with amendments.
Honorable members, I put the question, which is that the committee do report to the House its consideration of the Perpetuities and Accumulations Bill, National Assembly Bill number 24 of 2021, and its approval thereof with amendments. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it.
At what time are we going to call her? Because I want to leave. Go prepare. Leave. You go to the office. Where for what? So we are done now. Yeah.
Mr. Speaker.
Yes. Who apply?
Honorable members, let's start with the Public-Private Partnerships Bill, and I now call upon the Chair to report to the House.
Honorable Speaker, I beg to report that the Committee of the Whole House has considered the Senate amendments to the Public-Private Partnerships Bill, National Assembly Bill number 6 of 2021, and approved the same with amendments.
The mover.
Honorable Speaker, I beg to move that the House do agree with the committee in the said report. I also would request the Honorable Wangwe to second the motion for agreement with the report of the Committee of the Whole House.
Thank you, Honorable Speaker. Honorable Speaker, I do second. Thank you.
Order, members. Honorable members, I propose the question, which is that the House do agree with the committee in the said report. We will have to defer the putting of the question until the business comes back in the order paper. And members, let's move to reporting on the perpetuities and accumulations bill. And I call upon the chairperson to report to the House.
Honorable Speaker, I beg to report that the Committee of the Whole House has considered the Perpetuities and Accumulations Bill, National Assembly Bill number 24 of 2021, and approved the same with amendments.
Let's have the mover.
Thank you, Honorable Speaker. I beg to move that the House do agree with the committee in the said report. I also request Honorable Rosa Buyu to second the motion for agreement with the report of the Committee of the Whole House.
Honorable Buyu.
Thank you, Honorable Speaker. I second.
Other members? I go on to propose the question, which is that the House do agree with the committee in the said report. And on the same note, we shall defer the putting of the question until we have it next in the order paper. Next order.
Order number 12, the Asian Widows and Orphans Pensions Repeal Bill, National Assembly Bill number 29 of 2021. Resumption of debate.
We are resuming
debate on this motion, and I believe that the committee report has been tabled. Yeah, so we had a few members who had made their contributions. It had been moved, seconded, and we had 3 members, Honorable Kenta, Dan Mwashako, and Edith Nyenze had contributed. So we can move on to Honorable Shamalo. You want to speak to this? Honorable Shamala, you're on something else, huh? Finance Chair, Honorable Wanga. The Asian Widows and Orphans Pensions. Are you speaking to it?
Yes. Thank you, Honorable Speaker. Honorable Speaker, thank you for giving me this opportunity to make a contribution to the repeal of the Asian Widows and Orphans Pensions Bill. Honorable Speaker, this repeal is long overdue because the Asian Widows, the fund, was a colonial days fund. In fact, the last time this fund was ever operated was in the 1980s. It was a fund whose returns were being made back to the Crown in the UK. So, Honorable Speaker, since the 1980s, this Asian Widows and Orphans Fund has been dormant. But yet we have an active bill speaking to the issue of the fund. So, Honorable Speaker, I want to thank the Majority Leader for bringing in the repeal, because now, once and for all, we are going to wind up the Asian Widows and Orphans Fund, which is a colonial concept. Now we only have pensions for Kenyans, not separate pensions for Asians, not separate pensions for, Muslims, Christians, Hindus. This was discrimination of the old times. So, Honorable Speaker, it is a timely move to repeal that bill so that we all operate within the context of our pension funds, the NSSF, and other pension funds as regulated by the Retirement Benefits Authority. Honorable Speaker, one of the things that came up was whether we are able, our Special Funds Committee here is able to have a terminal kind of audit for this fund, so that we know whether the fund has any assets or liabilities, and what is the status of these as the fund is wound up. So one of the recommendations of the committee is to have, if it's possible, to have an audit, although there was still an argument as to whether we can bring back the documents from the Crown, from the UK, in order to be able to audit them. So this was put in as a proposal. We don't know whether it's practical, but it was put in as a proposal nonetheless. So, Honorable Speaker, this is a straightforward matter. For a fund that has not operated since the 80s, it is not useful to have an operational bill. So once again, the committee agrees with the Majority Leader in proposing to repeal completely this act, and so that we channel all our energies to the current pension mechanisms or social security mechanisms that the country has. So, Honorable Speaker, the committee gives its support to the repeal of this act and thanks the Majority Leader, and I also use this opportunity to thank members of the committee for putting in effort to ensure that this report is turned around within the shortest time possible. Honorable Speaker, I beg to support.
Honorable Okwome Adipo, member for Karachuonyo.
Thank you, Madam Speaker. I beg to support, because honestly, there is no need for this law to exist anymore in the books, because Asians are long gone, and that kind of pension arrangement is also gone, And in addition, we now are RBA taking care of.
Honorable Shamala, what's out of order?
Yes. I heard the Honorable Member of Parliament saying Asians are long gone. There are a lot of Kenyan Asians. The bill is not about a particular racial grouping, ethnic grouping. It is about the pensions fund, as was explained to us by Honorable Gladys Wangwa, which was a colonial instrument, and that Asians of Kenyan citizens, or Asians who live in Kenya, are still here and still can benefit from pension funds within the new frameworks of the law that we have.
So it's a sort of a point of information, which I don't know if it's clear to the Honorable Member what the Honorable Shamala is saying.
Thank you. But the point I'm making is that we now have RBA, we now have Kenya government making all kinds of arrangements for pensions for the staff. And I therefore support this bill. Thank you.
Honorable Sankok.
Thank you very much, Honorable Speaker, and incoming Governor of Narok County, for giving me this opportunity to support this bill. I know Honorable Wanga is very excited because you, the female members of Parliament, will dominate the governorship in 2022, and most likely one of you will be the chair of COG. So, Honorable Speaker, I support this one. I support this one, Honorable Speaker, because it is a move that is long overdue. And if a bill have been dormant for more than 30 years, I think it was just in good faith that the committee thought that it is good to do away with it. It's not only because of being dormant, but, Honorable Speaker, it was a kind of segregation and a kind of prejudicing against Asian, pitting them against other Kenyans, Honorable Speaker. Because if you have a fund that is specific to a race, Honorable Speaker, you are either saying that race is superior than the rest of us, or the rest of us are superior than that race. That is why we cannot use the same pension. Honorable Speaker, and it was colonial. And you remember in the colonial days, we were there was a kind of segregation in which even our schools were segregated. There was the African schools, schools for the Africans, there were schools for the whites, there were schools for the Asians, Honorable Speaker. That racial discrimination is what the whole world is against, Honorable Speaker. So if this committee thought that it should repeal it and do away with it altogether, so that all Kenyans are treated as equal, Honorable Speaker. In the colonial days, Honorable Speaker, even toilets were kind of, there was segregation, Honorable Speaker. There were toilets that were only used by the whites. Now those which are used by the African, Honorable Speaker. Still, when you go into pension, Honorable Speaker, and put a race that it is, this pension is only reserved for this race, Honorable Speaker. It is a prejudice, and we should all be up in arms against it. Honorable Speaker, what I want also to know from the committee, and I'm sure Honorable Gladys Wanga is listening, the incoming governor of Homa Bay, if there is any amount of money that was left in that fund, if it is there, then what will we do with such an amount of money? Will we reserve it for the Asians, or will we probably decide to give to the weaker members of our society, persons with disabilities, orphans, and vulnerable? No, we are saying it is a bill that deals with a fund. So we want to know the fate of the fund if there was some check balances, if there was some bank balances, Honorable Speaker. Honorable Speaker, we should know how then the transition will happen when there are bank balances, because once this bill is repealed, it is no longer a bill, it is no longer an act, it will not govern anything. So it's just in good faith to be able to know if then the bank account is reading zero, then we have no problem with it. Honorable Speaker, lastly, we will like Kenyans to learn from this bill as we repeal it and throw it away. What was the import of it? What was it doing? Are our current pension doing the positive things that probably this bill was doing in the late 80s and 70s? Was it serving that particular society, that's a particular race of the Asian? Can it now serve all the Kenyans so that we don't lose some very important points from a bill just by repealing it? Honorable Speaker, with those remarks, I do support.
Honorable John Bunyasi.
Madam Speaker, I support the proposed repealing of the bill, but I'm completely horrified at either our very short memory or lack of research. The arrangements that led to this were part of the architecture of our Lancaster Conference. And later at independence, for those communities that opted to take British citizenship, the agreement was that their pensions would be guaranteed on the other side in Britain. And they gave this management of the pension payment to Crown agents. The fact of the matter is that over time, the amounts were so small that the cost of the Crown agents was exceeding the value of the pension. I can appreciate all those reasons why I should wind it down. But let's not go on record in the National Assembly of this Republic to say the things we are saying. It shows that we haven't really thought through. I know that people are quite young. They were not there. They can't do it from memory. But we should do research. And I think that whereas we should indeed pursue the timely transitioning of this pension, because I remember when I was on the Public Accounts Committee some years back, when they attempted to go and do a review, many of the pensioners were either not traceable or they found the pension so small. Some had like £5 or something, and the cost of getting to London somewhere was much greater than that. So there are many good reasons why it should be wound down. But for heaven's sake, let us do it in a manner that's consistent with its background. And I think to do that also, there may be need to get an orderly transition between the government of Kenya and the government of the UK. It's not for the reasons of segregation that it was put there. It was that at independence we agreed on everybody to choose where they want to go. So I really think we should do this in the context of why it was set up. Thank you, Madam Speaker.
Honorable Akinyi, member for Kisumu.
Thank you, Madam Speaker, for this opportunity. Madam Speaker, the Constitution of Kenya makes every Kenyan, regardless of their gender, regardless of their age, regardless of their anything, equal. Madam Speaker, under the Constitution, more so the 2010 Constitution, we are all equal and governed by the supreme law of the country, which is the Constitution. Madam Speaker, there is no way that in the place of this country, we could have a law that discriminates or a law that's specific for a certain group. Madam Speaker, in this moment of the great movement of Kenya, movement of unity, movement of nationalism, movement of oneness, also dubbed as Azimio la Umoja, you cannot have any law or any specific law that is just tied to one group in this country. Madam Speaker, because of that, I stand to support the repeal of the Asian and Orphan of the Asian Widows and Orphan Fund. Thank you, Madam Speaker.
Honorable Launda.
Thank you, Honorable Speaker, to give me a chance to contribute to this bill. And probably let me take my colleagues, as Honorable Bunyasa has done, on a journey of history. At independence, there was fear and antagonism and uncertainty whether people of a certain race would remain in Kenya or not. And I think during part of the negotiation for independence, those who did not choose to want to remain in Kenya and had served the crown for many, many years were allowed to relocate from Kenya, and that goes with their pension. Having worked for the country for many years, that went with their pension. Honorable Speaker, I sit in the Public Account Committee, and the issue of pension to the people living outside this country is becoming an audit query every single year. For the simple reason that, first of all, tracing the beneficiaries or the dependents is not easy. It has been a problem, and the amount being paid as pension is so meager, so negligible, to an extent that the cost of administering the fund far much outweighs any charge on the consolidated fund. So it has always been an agreement all along that as we try to put into place a more robust pension management scheme, the pension schemes that do not make economic sense should be wound up, or an alternative way is found to ensure that we proceed. That's why I want to join my colleagues to state that there must be some kind of orderly transition as we repeal the beneficiaries who still benefit by virtue of having served this country in various capacities before independence do not get denied what is due to them. So therefore, we do hope there could be a provision in the bill to provide for a transition period where everybody should be able to get their funds. Honorable Speaker, I think it's wrong for any members to insinuate that this particular was favoring a certain category of Kenyans. It wasn't. It's a historical matter that needs to be put in perspective so that all of us understand the genesis of the bill and why it's being repealed. With those few remarks, I support the repeal of the bill.
Honorable Manje.
Thank you, Honorable Speaker, for giving me this chance. I want also.
Sankok, why are you on intervention?
I'm rising on Standing Order 53.3. Please, I will request the Speaker to defer the putting of the question on this bill, on this motion, pursuant to Standing Order 53.3.
Maybe later, Honorable Sankok, not at this point.
Yes, I've seen there was no interest.
Once we, Honorable Sankok.
Yes.
Since when did you become the speaker? How do you know?
Thank you.
Take your seat. Honorable Manje, continue.
Mr. Sankok, I was speaking. I was there already.
What is it, Majority Whip?
Thank you very much, Madam Speaker. Madam Speaker, the standing order in this House gives us direction that we only have two languages that is known for us. And the Honorable Sankok spoke some very advanced English or foreign language, which looks almost like a Maasai language, almost, Speaker. Is it in order, Madam Speaker, to proceed and be answered in that direction? Thank you,
Honorable
Madam
Sankok,
Speaker.
I don't know what you said, but just to remind you that the only languages you can do is English, Kiswahili, or sign language. And you need to stick to that. Now let's have Honorable Manje continue without interruption.
Thank you, Madam Speaker. I want also to support this committee on the repeal of Asian Widows and Orphans Pension Bill, and say because of the time lapse, I think it has stopped serving the purpose that it was effected for. Because at independence, that's when this bill was enacted to effect the payment of pension for those who, the Kenyans who decided to leave, to go other parts of the world. And it has been distributed through our embassies. So with the time, this kit has become small, and also tracing the beneficiaries has become a big issue. So if you check our books of auditors, there has been an audit query every time because of this inability to trace the beneficiary. So I think it has been overtaken by events, and therefore it is the correct time to repeal this act, so that at least we can use acts that are effective and that are efficient. Also, because of the emerging issues, you know, when you are living in a different country, for example, London, you'll find that the shilling compared to the dollar on the other side is becoming weaker as you continue. So due to that, it is becoming negligible and that not cost effective. So I support this repeal.
Honorable Shabir, member for Kisumu East. Give the floor to Honorable Shabir. What's happening? You can use the one behind you. Just look behind you. Turn it on. Which one?
Hello? Yes, Madam Speaker, I wish to address this issue of the widows and the Asian widows pension. Firstly, you know this one, since the last...
Is that microphone on? Can hardly hear.
My understanding is that the last real transactions took place in 1980 something. Since then, there have not been real transactions on this particular fund. Yet, there is a board sitting somewhere and being paid all those 22 years or 24, nearly 40 years. And we want to understand, what is this particular thing doing? You see, my grandmother used to get a pension through the Crown agents. So we know we are repealing this, which is very important we are repealing. But at the same moment in time, Madam Chair, Madam Speaker, we need to know, when you're repealing this thing, whether we can have a final audit of what has happened, not of the transactions, but at the final audit. You know, when I was a mayor, Madam Speaker, towards the end of a particular session and before the others, that was the most dangerous time, where a lot of assets were disappeared and a lot of things were happening. So while we are now repealing this act, we must ensure that there is what we might call in accounting terms a finalization or a termination audit. I know the majority leader knows what we're talking about. But the other thing we need to know is, have these people been ghost workers for the last 40 years? And do we need to understand who has been sitting on the board when there's been no transactions for nearly 40 years? So this is the sort of waste that we want to clear out. Yes, we're repealing it. It's very good. But we must also look and see whether we've done the right thing. Apparently, there is some money still in that account. Who is utilizing that money and how it is being, who is allocating it, whether it's been budgeted for every year and for what reason. So, Madam Speaker, it is very important that we get to the bottom of this. Repealing it is the easier option, is the easier action, but this action must be implemented together with a termination audit to see whether people have taken advantage of this particular scheme that has been moribund for 40 years. Thank you, Madam Speaker, sir.
The Honorable Shamala.
I've already spoken to them.
You did not?
You were not here, you just said.
I see no further interest in it. The mover to reply.
Thank you, Honorable Speaker. Honorable Speaker, I rise to reply to this motion, I want to thank members for the manner in which they've contributed. It's a simple, straightforward task of deleting or removing this from our statute books for laws that are basically dead and overtaken by time. And I just want to reassure members, including my friend, Honorable Shakir Shabir, that indeed the transitional mechanisms do provide for a review of what has happened, what's in the fund. An amount due to the fund will be collected, an amount payable by the fund will also be determined, and there's a time period of 1 year during which time all these reconciliations will be done, so that we don't just repeat an act and hang, there's some money in the bank, there's some people with, so the various mechanisms have been put in place within the law to ensure the smooth transition from this to the pension funds envisaged under the PFM Act. So I think that's really the only comfort I want to give members, that everything has been taken into account in terms of the worries, and we shouldn't have any issues as we repeal the fund. With those remarks, I beg to reply.
Very well. I direct that the next steps in regard to this business will be undertaken when the matter will be set down on the order paper, and direct that we move on to the next business on the order paper.
The County Government's Grants Bill, Senate Bill number 35 of 2021, resumption of debate.
Honorable members. Honorable members, this business had been moved and seconded, and debate was to proceed. And the first member with interest in this is the Honorable Wangwe, the majority whip.
Thank you, Honorable Speaker. Honorable Speaker, I rise to support the County Government Grants Bill, Senate Bill number 35 of 2021 by the Committee on Budget and Appropriation. Honorable Speaker, I am a member of this committee. We actually went through this report before it was tabled today, and the report is comprehensive. It has informed members on actually the whole scale of the proposed bill, and therefore, Honorable Speaker, I second with a lot of information about it, Honorable Speaker. Honorable Speaker, the main gist of this bill is to set a framework, Honorable Speaker, on pursuant to Article 202 of the Constitution in terms of the conditional allocations for the financial year 2021-2022. Honorable Speaker, this is to facilitate the transfer of conditional and unconditional allocations made to counties under this Act from the consolidated fund to the respective county revenue funds and special purpose accounts, Honorable Speaker. Honorable Speaker, this bill provides a legal framework, the way I've said, and mainly it is touching on the grants and the donations for the 47 counties for an opportunity to utilize well the funds and obtained under the equitable revenue sharing funds, Honorable Speaker. This being such as operational and staffing issues inherited from the defunct local authorities, as even they look into the strategic issues that will enable them to raise their own revenues in an efficient and effective manner. Honorable Speaker, when you look at the various kinds of conditional allocations for the financial year 2021-2022, which we'll now be looking at in terms of the headquarters to various institutions, various counties, basically amounting to 332 million shillings. This going to Isiolo, going to Lamu, going to Nyandarua, going to Tano River, going to Tharaka Nithi. Honorable Speaker. Honorable Speaker, these conditional allocations, which will be for the leasing of medical equipment and shared equally among the counties at a rate of 153 million shillings. In total, Honorable Speaker, we are talking of about 7.2 billion shillings. Honorable Speaker, in this bill, the conditional allocations financed by proceeds of loans and grants from the development partners to each county governments for the financial year 21-22, totaling to about 32 billion shillings, Honorable Speaker, which will include about 2.2 billion being World Bank funding, transforming health systems for universal care projects. Conditional allocation through the Ministry of Health is meant to improve delivery, utilization, and the quality of primary health care services with a focus on reproductive, maternal, newborn, child, and adolescent health at the county levels. Honorable Speaker. Honorable Speaker, there was various public participations which we have read in the report. And the report, Honorable Speaker, for my colleagues, maybe it was tabled this afternoon. It's in the table room. So I just want to remind my colleagues, please access the report which is available in the table room. We actually interrogated the Council of Governors. We interrogated the Control of Budget. We interrogated the Commission on Revenue Allocation. We interrogated the National Treasury. And the bill grants that shall be released, the bill grants shall be released to the county revenue funds account upon compliance with the conditions set out by the National Treasury for the fund. Honorable Speaker, there are issues which we have highlighted in the report, which is important that, Honorable Speaker, members get to be aware of, that the bill, if passed as proposed by the Senate, would be against the Justice Makau ruling on petition 252 of 2016 on 3rd December 2020, Honorable Speaker. 2, the clause shall also make it an annual bill should be removed. The clauses that make it an annual bill shall be removed. This will enable the bill to provide for disbursement of conditional grants to counties pursuant to Article 207 of the Constitution, Honorable Speaker. We also observe that the bill provides for the procedures for implementation, reporting, and accountability of the funds, including the roles and responsibilities of various institutions, Honorable Speaker. Honorable Speaker, in conclusion, I would want to make suggestions through the committee that we shall be also, the committee will be looking at the various amendments, Honorable Speaker, which have been, have come which are showing up in the bill, that will be proposed in terms of the title of the bill, in terms of the clauses number 2, the object of the bill, and we shall also be requesting some deletions, Honorable Speaker, of some various other clauses which are to align with the Constitution as per the observations we have made, Honorable Speaker. Therefore, Honorable Speaker, this bill is also going to help, in summary, facilitate the National Treasury to facilitate the agreements between the county governments and development partners, and this shall be tabled in Parliament before inclusion in the budget policy statement. Honorable Speaker, that position has been missing, and if it can now be adopted as proposed in the report, Honorable Speaker, to correct the bill and align it with the Constitution and the PFM Act, Honorable Speaker, it's going to be a good thing, and it will be enrich it for perpetuity, Honorable Speaker. Finally, the additional allocations, Honorable Speaker, with respect to loans and grants, the National Treasury shall include in the budget policy statement the indicative amounts to county governments on loans and grants. Honorable Speaker, as we do this, it's also important to inform the county governments that, Honorable Speaker, whereas this House appropriates funds to them, it's important that they also proceed, and when they are doing their budgets down in the various counties, Honorable Speaker, allocate the same funds equitably, not necessarily to be equal, but, Honorable Speaker, let them distribute the funds in terms of allocating the funds equitably across the county. Let's not witness some skewed kind of allocation in terms of our political belonging, so that those which, the areas, for instance, the wards, which are not aligned to a particular governor, end up not getting the funds, Honorable Speaker, just because they speak a different political language. It's important to note that this is not county funds, this is Kenyan funds, which has been gained from the consolidated fund, and the consolidated fund, Honorable Speaker, gets money from the taxpayers, and we don't separate taxpayer from where KRA collects the funds. Therefore, we need to see a replica that from the national government rolling down to the county governments, let the counties observe equity, not equality, Honorable Speaker. With that, I support the bill. Thank you very much.
The Honorable Undo.
Thank you, Honorable Speaker. When I peruse through this bill, I find so many contradictions. I find so many issues that do not really align to the Constitution. But Honorable Speaker, let's start where we started. Initially, the bill used to come one, but I think after the ruling by the High Court, it became necessary to segregate between conditional grants and unconditional grants. And this is meant for the national government to infuse or transfer funds to the various counties that address specific needs of the people of Kenya who live in those counties as a result of historical issues or as a result of emerging issues. For example, Honorable Speaker, a very clear example that the advent of devolution, many counties did not have decent headquarters. So over the years, the national government, through the Division of Revenue Bill, have always allocated funds for the purposes of constructing and completing those particular county headquarters. Honorable Speaker, obviously, universal health is central to this country. So therefore, many of us believe this might have informed the national government to basically transfer funds for the purpose of leasing equipment for medical services. Nevertheless, Honorable Speaker, looking at the bill, it is a progressive approach, but I would want to pick out a few issues. Number one, the title is again misapplied. The money being granted is both national funds and funds coming through the loans guaranteed by the national government. Based on the schedules provided, the ones coming in terms of loans are 32 billion. Couping 32 billion, those coming as conditional grants are 7.5 billion. So essentially, Honorable Speaker, these are not county-generated funds. These are funds generated by the national government and guaranteed by the national government. The bill, that is the title of the bill, must speak to that reality and not confuse Kenyans to believe that these funds that have been generated by the counties themselves, now they are sharing amongst themselves as if they generate anything much. That's the first issue, Honorable Speaker. Honorable Speaker, the second issue, if you read through the thinking of the bill, is that this is going to be an annual bill. I wonder, and I should have to ask, what happens in the end financial year? The national government has no intentions at all to give conditional grants or to secure loans and disburse to the county governments. That is an area that needs to be addressed, and I do believe the committee and the legal team will help us address that particular concern, because this is actually the benevolence of the national government. It can choose to or not to. Because looking at the bill, Honorable Speaker, when they are making amendments to the Public Finance and Management Act, they are proposing under their clause 8 of their bill, when they are making amendments to section 42 of the Public Finance Management Bill, to assume that the Parliament shall consider Division of Revenue Bill, the Counter Allocation of Revenue Bill, and a bill for the allocation or transfer of conditional allocation under Code 202 of the Constitution not later than 30 days after the bills have been introduced with a view to approving them with or without amendments. Again, it might be important we review that particular clause at the Committee of the Whole House and will be ably guided by the committee that is handling this matter. Honorable Speaker, the interesting part, and which I think is progressive but not progressive enough, is the requirement for the national government and the respective county governments to have an intergovernmental agreement for the purpose for the transfer of the funds. It provides various procedures, and a curious one is that the agreement must be approved by the respective county assemblies within 14 days. We wonder, are they 14 sitting days or 14 calendar days? That needs to be clarified. But the most curious part, Honorable Speaker, is that after it has been approved, that's when it's subjected to public participation. I wonder which comes first? Is it public participation before approval, or approval then public participation? Then public participation will be just a facade or a charade, because addition will have already been done. But the main omission in this bill, Honorable Speaker, is the lack of accountability. The amendments being proposed by Senate provides no room for accountability. These are government funds, national government funds, allocated by the by this House, by the National Assembly, making no provisions whatsoever for a way to account for these funds. That is actually setting an extremely dangerous precedent where these county governments will enter into agreement which they have no intentions to enforce and misuse the funds. As Honorable Angwe has said, there are many cases in this country where funds are devolved to the county governments, and because of political differences or because of future political consideration, funds are only spent or utilized in one particular constituent sub-county to fulfill certain political goals. Honorable Speaker, one of the obvious cases that we'll have to do, we will have to amend to require that there must be some form of accountability to the national government as they account to the Senate. Yes, there's a provision to submit reports to the budget, control of budget, but the control of budget only deals with the matters before, during disbursement, and not how the funds are used. What happens is that the government has guaranteed loans from various places, and yet the funds are misused or not applied for what was provided for in the agreement. So there must be a provision for review or monitoring and evaluation to confirm that the funds have been utilized. So there must be such kind of an arrangement that we must put in place. Honorable Speaker, as I conclude in support of the bill, of course with subject to amendments later, is just to make two issues. The main intention when serious political leaders in this country fought for devolution was to make devolved units the engine of development. Honorable Speaker, if you do a simple rundown, that has not been achieved. We have pumped into devolved units billions and billions of money, but what you see on the ground, as they say, things on the ground are different. So therefore, Honorable Speaker, as we continue to improve the management and disbursement of funds, we must put in mind what is value for money. Are Kenyans getting value for money? Or will it be in the best interest of the national government, instead of giving these funds as conditional grants, they use our line ministries to implement specific projects that affect or benefit the people that are supposed to benefit, the same way we have done with the CDF. Honorable Speaker, if you go to many constituencies, the projects and the works of CDF stand out very, very clear and outshine the works of county governments, yet the county governments get colossal sums of money. Second, Honorable Speaker, it is important the county government, as we give conditional grants, as we give disbursed loans received, they must also up their game and literally collect internal revenues. There is so much proliferate, there is so much loss in various cesses and levies they are allowed to collect. It was never meant that the county governments will solely depend on national government to fund their activities and their programs. Many times, you hear county government staff have gone without pay. If you meet them, you ask them, what do you do with the collections that you get from markets, cattle dips, mortuaries, and the rest? They simply say, we never know where that money goes. And this is where the Senate should have trained their eyes, spend all their time in policing and supervising and oversighting the county governments. Instead of wasting time doing things that are not theirs, wasting time trying to fight the National Assembly when they have no powers at all to fight the National Assembly. Finally, Honorable Speaker, the issue of corruption, values, and integrity. We must continuously infuse in our county governments because they hold a specific and a very serious position in our county. If BBI had gone through, 50% of the national funds would have gone to county government. 50% requires for us to see value for money. With those few remarks, Honorable Speaker, I support.
The Honorable Sankok.
Thank you so much, Honorable Speaker, for giving me this opportunity to also palm my voice into this very important bill and report, Honorable Speaker. Honorable Speaker, the conditional allocation grant, which is approximately more than 7 billion per county, Honorable Speaker, is not chicken change. It is money that should go with a lot of condition by the national government, set so that they should be followed, lest we continue having what we are seeing in county government, where 80% of all the money that they collect and receive from the national government go to payment of salaries and go for what we call recurrent budget. Sometimes public participations, recurrent budget in terms of office operation, having sodas, having tea, Honorable Speaker, and local and international travel, Honorable Speaker. And that is why we are not seeing value for our money, Honorable Speaker. We are not seeing, as the Honorable Ounda said, Professor, that things on the ground are different from the much that we have been allocating to the county governments, Honorable Speaker, in that allocation that we have been doing, Honorable Speaker. Honorable Speaker, I have heard from the bill, because I have gone through the bill, Honorable Speaker, that there will be public participation after approval. Honorable Speaker, talk of priorities upside down or downside up, whichever way you like to put it, but that is what they are doing, Honorable Speaker. And we need, Honorable Speaker, we need really to be very careful so that we will not do public participation in vain just to satisfy the requirement of our constitution, but it will not add anything, because if you have already approved, then what is the essence of public participation? Supposing the public does not need it, supposing the public give suggestion of, very good suggestion of what is supposed to be done, but it's already approved the way it was, Honorable Speaker. Honorable Speaker, again, from that bill, it is supposed to be yearly or annually, Honorable Speaker, meaning the county governments will be at the mercy of the national government. The national government may decide that this year they will not, they will use their massive tyranny of numbers in the National Assembly or in the Senate, so that then the bill is not passed. So they will not receive the grants, Honorable Speaker. Honorable Speaker, we also want to check on the issue of equal distribution of this conditional grant, Honorable Speaker, so that, as other honorable members have said, we don't have distribution in terms of political patronage. Honorable Speaker, what I have in mind is a governor who have completed his 2 terms, and he have the intention of contesting in a single constituency within his county. Is, Honorable Speaker, naturally that he may be biased towards taking a lot of development to woo voters in the constituency that is intending to contest, Honorable Speaker. So, Honorable Speaker, we really need to be very careful on this, so that the bill include some of these very important additions that we are putting in, Honorable Speaker. Honorable Speaker, the other issue is the Senate, and Professor Ounda have said that the Senate, this is your work. It is actually that you should oversight counties, but the Senate have been very amorphous in terms of what they are supposed to do. That is why earlier I said that it is an amorphous political civil society. It's like an activist club that is just there. Honorable Speaker, you can imagine them summoning even the Interior Security Minister, summoning the Foreign Affairs Minister, Honorable Speaker. And they understand, according to our Constitution, Schedule 4, what are their mandates, Honorable Speaker. One of their mandates is to oversight the counties. And oversighting the counties mean they should not only be recipients, but also they should be generators of income through collection, Honorable Speaker. Honorable Speaker, but don't think that they are not collecting a lot of revenue. They are collecting. In Narok, Masai Mara Game Reserve is one of the biggest tourist attraction site throughout Kenya, Honorable Speaker. Honorable Speaker, we also have sand. We also have building stones, Honorable Speaker. But Honorable Speaker, what have happened is that they make official receipts, which is 10%, 80% receipts, 80% of the receipts are made in River Road, where then they will be collecting revenue and are not remitted to the banks, Honorable Speaker, and they don't reflect. And that is why when you ask why they are going without salary, Honorable Speaker, and yet they collect a lot of money, as Professor have said, from mortuaries, from cattle dips, from marketplaces, Honorable Speaker, from business licenses, Honorable Speaker, from those lorries that transport sand and the tourists that visit some of these tourist attraction sites. Honorable Speaker, you may not know where this money goes to. So I think the Senate have a whole big enough work in their hands, Honorable Speaker. They have a full tray, but they decide not to perform their duties. Instead, they now want to compete with the National Assembly, Honorable Speaker, and I think that one they cannot, because the Constitution is very clear. So, Honorable Speaker, with those very many remarks, I support, but again, we need to sit down in the committee of the whole House so that we can input in terms of amendments, so that we have a very good report that is not a report from our brothers from the Senate who may not be able to do much research and who don't know their work. Honorable Speaker, we should show that we are the upper house and that we understand and we know our work and we know what is good for this country. With those very many remarks, Honorable Speaker, I support.
The Honorable Sankok, I do not think that the Senate doesn't know its work. I'm sure they know their work. It's just that sometimes they are they overreach, which is normal for people to want more than is really theirs. But I'm sure they know their work. The Honorable Shabir, member for Kisumu East.
Thank you, Speaker, sir. Speaker, I want to take on from my colleagues the County Government Grants Bill. The purpose of this bill and the object is to put together a framework to provide for Article 202 of the Constitution for conditional allocations and to facilitate the transfer of conditional and non-conditional allocations. That's what it says. When you look at the attachments, you can see the problem. The problem of conditional grants is exactly that. It is a conditional grant. And if the conditional grant must be accepted or rejected by the county. If I look at this document, Mr. Speaker, sir, at the last page, it says every county in Kenya got 153,297,872. For what? For conditional grant leasing of medical equipment. Now, this particular bill has not addressed the point of what if you are being given a conditional grant that you do not wish, you do not think is value added for money. This particular one, which was medical, I know for a fact that certain counties said we didn't want it. Yet here, in the first schedule, it shows every county has actually been given that conditional grant. The question really here, and I can't see it anywhere, is what happens if a conditional grant is given to you and you use it for something else. It's not here.
Then, under one of the sections here, which I don't, it tells you the rest of them, conditional grants are IDA World Bank Transforming Health Systems for Universal Health Care Project, IDA World Bank Credit National Agriculture and Rural Inclusive Growth Project, IDA Kenya Climate Smart Project Agricultural Project, EU grant instruments for devolution, advice and support. It's about 14 of them here. Does that mean that say the World Bank sends you money for transforming of health services or systems, and you and us as Kisumu County feel that this conditional grant that you're giving to us does not match the needs of our county? It appears that this is an automatic thing, that whatever the conditional grant is, it will be divided by 47 and given across the counties. So I can't understand the logic of this thing other than the fact that by way of this bill, and I agree with my brother Songkok, either we... Sakox, beg your pardon, sir. I beg your pardon. I'm so sorry about it. I share that concern. The concern is, maybe I don't understand this bill, but this bill literally is just laying out conditional allocations and giving the organization, giving the county no particular say, and all this is saying is this books, they will be given to you without going through the single account, what is it called, the conditional, it should be through, without going through the consolidated fund for the respective county. Now the consolidated fund, for whatever problems we have with it, it has one strength. It has control mechanisms, and it has issues that can be followed through. I am wondering whether this special grant system is going to bypass that consolidated fund. Do we have mechanisms to make sure that we do not get something like the Aurora Dam or other things just allocated through the system to the counties? I'm being sort of facetious. Let's say that the World Bank comes and says, we are going to give you so much for climate change. So you divide that money for climate change by 47 counties, the way they have done health. Does that mean that there is no mechanism for understanding the needs of the county? There is no mechanism for saying that this is how we should do it? There is no mechanism for deciding what is value for money? The consolidated fund has that mechanism. So either I'm taking a very simplistic view that the Public Finance Management Act, it says they require it to be amended by section 42 by substituting and putting a new section, that the Parliament shall consider the division of revenue bill, county allocation of revenue bill, and the bill for allocation and transfer of conditional and non-conditional under allocations under Article 202 of the Constitution no later than 30 days after the bills have been introduced. So we understand the first one, division of revenue, and this has been the main, but where does it come? Where does this conditional grants come in? It is a bane. We don't understand, and it's been a big problem between this House, and the majority leader will understand more than I will, between this House and Senate. So I'm wondering, if this bill has come over here, should we not send it back to Senate and say, listen, we don't understand exactly what you want, because they don't tell you exactly what you want. They're just saying that we want to give this exemption. So this bill, this money of conditional grants shall not go through the consolidated fund. It will go directly. Who will decide? What are the mechanisms for for looking after that money, and one of my colleagues here has also raised serious concerns. So, Mr. Speaker, sir, I do not support this bill. Thank you.
The Honorable Mwali Ombithi, member for Masinga.
Thank you, Honorable Speaker, for this moment that I've been able to get the bill. Although I've not read about it so much, but I understand how this conditional bill works, and I would like to just point a few things in my support. Conditional allocation means additional resources allocated to the county government apart from the normal budget which they have. I happen to interact with some conditional grants given to some of the counties for some specific projects that those counties are undertaking through those conditional grants. And the good part of these conditional grants is they are controlled by the giver. If it is the European Union, they will specifically send a coordinator for that account, and that account is normally not operated by the normal government officers who are able to even transfer the funds. This man is controlled. It is not transferable. They cannot even divert this money to another project. It is only when the European Union, for example, signs off for the project that the project can be paid. So to me, this additional grant which is being proposed is a good idea, because the money that the national government is giving the counties, majority of it is going to the recurrent expenditures, and therefore you find there is nothing, or there is very little that they are able to do in terms of development. So if, for example, they give a grant, the World Bank, especially when they are saying they are giving for universal care, then they will appoint their own people, and that universal care will be able to be developed, so that it will take it together with the government funds. It will complement what the government is giving, and therefore I think this is a good bill. If only it can be passed, and we vote for it, and maybe with a few amendments on the controls, it will be able to help our counties. It has been very difficult for our counties to do any meaningful development. I take an example in my constituency. The county government has only been able to do only 3 boreholes since I was elected in 2017. And that means if there was some conditional grants that given to the counties for water, for universal health care, even the hospitals could be stocked with some drugs and also be improved, build some maybe mortuaries. For example, if a person dies in my constituency, they are transported to another constituency, because there is the entire constituency has no mortuary, because the county has no extra funds even to build one. So to me, I find these funds to be very useful, and we as Parliament, I will wish that we support that the bill goes through, so that even the partners that are willing to give the conditional grants can go ahead. With those few remarks, I support.
Leader of Majority.
Thank you, Honorable Speaker. Honorable Speaker, I rise to support this bill. and to thank the Committee on Budget for having quickly considered this bill over the weekend. I know, even from the discussion by members, it raises a number of issues that will need to be brought at the Committee of the Whole. And hence, it's good that at least we record our appreciation for the work they've done. From my reading of this bill, it raises, basically, it is twofold. And the first thing is attempting to approve in retrospect what was done through the Division of Revenue Bill of 2021-2022 earlier in the year, when we passed it and we said this is the money that goes to the counties as conditional grants, and this is the money that goes to national government. Why Senate wants to do that, I'm yet to understand. Because as the ruling the Speaker did allude to was very clear, the Senate has no powers on appropriation of money. That is a power that is resident in this House. And in any case, we already appropriated that money. So when I see that one of the objects is actually to appropriate money for 2021, 2022, and they even go ahead and schedule a list, I see mischief, and I see the Senate is probably trying to start the appropriation process through the back door, so that come next year, they will then do another one for 2021, 2022, 2023, and put some other figures and force us to agree with them. So I think there is something that we need to agree upfront, that you don't put in law that this law will apply for this year and this amount unless it's an appropriation bill. And we already have the appropriation bill that gave effect to the budget for 2021, 2022. So I think that's one of the things that I want to see how the Budget and Appropriation Committee will handle that, so that when we come to the Committee of the Whole, we should delete all references to 2020, 2021, and just leave the generic issues in terms of this is how you appropriate laws, conditional grants to counties going forward. We cannot go back to history because we already have a law that covered that. And I really can't see what rationale they would have, because we are not in a vacuum. This House already appropriated this money. This money has already gone. And now, even now, trying to schedule and put within the law, these are the donors and all that. Supposing one of them changes, what are we going to do? Bring the law here to come and start making amendments? Because the funding agencies that have been scheduled in clause 4, if any of those was to fall off after you pass the law, what happens? Right? It's in the law, and you're basically saying conditional grants must be received from these people and sent. This is poor drafting. It's obviously something that an overreach by the Senate, and perhaps it's a misunderstanding. We'll give them the benefit of doubt of their mandate and what they're going to do, because according to what I heard, is there was a court ruling that kind of said we should not mix the division of revenue with conditional grants. But that does not mean that we go back. And why 2021, 2022? Why not 2020, 2021 and before? But so that's my first concern. And I would wish that the Budget Committee does bring that amendment to remove any references to the particular year of allocation for a year, which we have already allocated through the laws as given in this country. Be that as it may, I believe the second bit, to facilitate the transfer of conditional and conditional allocation made to the counties, flows very well, and barring any reference to the year, it's something that we commend them for that. Now, when we devolved, some people are not quite sure when we were talking of devolution, whether we meant decentralization of services as can be done through the district forecast for rural development in those days. But when we devolved functions, it was, giving functions to counties, giving them money and the decision-making ability at the local level. And this takes place within the framework of the county integrated development plans, which then involve the people in public participation in terms of what are the priority needs, what do they want done, and then so they involve from that angle. But when we now come, that's for purposes of utilizing the national revenue that is shared through the Division of Revenue Bill and allocated to the counties through the County Allocation Act. But these special grants are actually specific to specific counties, and I want to correct the impression that I had that it's money that is equitably shared. No, when a specific funding agency decides that they want to fund some climate change issue, they might just look at where the water towers are, where it best can mitigate climate change issues, and will fund projects in that area. And hence, it's not about equity, it's about where the people want. And what is becoming very clear is that these conditional grants cannot be used for anything else. I served in the Education Committee, and I know there was 2 billion that we kept on being sent to the counties for purposes of helping, infrastructure grants to the youth polytechnics and the TVETs under their care. And most of this money ended up being used by the governors to pay for their salaries because it was delayed, but the money that was there for to upgrade these facilities was then used. And I think this law now takes care of those things that we are basically saying. When you receive money for a specific purpose, it's designated for that purpose, and you cannot use that for anything else. You cannot commingle that money with others, because we know money is fungible. If you take money from this pot and you put it together, you will not be able to see which money from which pot is in a combined pot. So it's only through systems and legal frameworks that we can be able to say, you have received this money for healthcare, keep it for healthcare, and only use it for healthcare and account it for healthcare. So I think I can't overemphasize why we did this. I know Senate perhaps has major limitations. When you look at Article 96 of the Constitution, it basically talks of Senate having oversight over the national revenue that's been allocated to the county governments. It doesn't talk about expenditure. It doesn't talk about the own revenue raised by the counties. So Senate can only oversight the national revenue that has been appropriated to the counties. And it's not even very clear what that oversight means. Whether it's to ensure that Treasury has sent the money, because it doesn't talk of expenditure. If it's expenditure, it would have been very clear. And I think we tried to bring that amendment within the Building Bridges Initiative, Constitutional Amendment, to just make it very clear, as an amendment to Article 96, that Senate shall have oversight over the national revenue and expenditure thereof, as well as own revenue and expenditure at the county level, so that at least they then have something to do. Granted that our devolved structure gives that power of oversight to the county assemblies. The governor appears before the county assembly, presents his budget, presents his county integrated development plan. They are approved by the county assembly. The budget is approved by the county assembly, and hence he's obligated to actually report an account to the county assembly. But again, when you look at the Constitution, there is some lacunas in terms of where there is that direct link in terms of how the governor is supposed to account to the county assembly. And we've seen cases where the governors have been choosy. When they think they are better friends in the Senate, they will go and try to appear before the Senate. When they think the Senate matter is hot, they will then go and appear before the county assembly and then claim double jeopardy relief. And hence, the matter disappears in between those two. So this is a good law, and like we are saying, I do hope we will enrich it further to also bring in, because conditional grants, those conditions don't just mean what you can use the money for. I will foresee a situation where Treasury should actually be giving a grant and saying, we will give you this money on condition that you raise 10% and demonstrate you've raised 10%, then you get the 90%. So that we can incentivize the county governments to actually make this own contribution towards the development project, and they can own the project. Because right now there's an ownership issue. Projects are funded through the national government. They don't care. The Ministry of Public Works is given the responsibility to go and set up those headquarters. The Nyandarua County headquarters started in 2003. Right now, I think it's still at slab level. Now, we are talking of 8 years, 2 governors, and it's still being done. They are still on some temporary accommodation, which tells you there's a big issue, either because of frustration, the coordination between what the national government is doing and what the county government is doing, and contractors keep on, leaving site and everything else. We've seen this conditional grants working very well within the road sector, with the roads that are co-financed by KERA, and I don't see why we can't have the same thing happening on the mega projects, including on the managed equipment scheme that seem to have some issues that I don't want to get into. That's for other people to tell us. So like I said, I'm in total agreement with the generic text, with the generic objects of this bill, but I'm totally opposed to the inclusion of references to the allocations for 2021 and 2022, including the schedules thereof, which are attached to this bill. And I'm not sure why we want to do them again when we already did the same through the division of revenue bill, and they were captured in the CARA. So I would want to ask the budget committee to actually clean up that for us, so that we pass this generic law, which will be used next year, and whatever happened in the past has already happened. In a case we don't pass laws into retrospect, we'll end up with more court cases, and I'm not sure that's what we want to get ourselves into. Or better still, yes, I'll take the information.
You wish to inform the leader of majority?
Thank you, Honorable Speaker. With lots of humility, to inform your boss on mic is not very good. But since he had spoken on the numbers in terms of preparing a document in retrogressive, I just wish to inform the leader majority that the numbers which are in the document simply make the benchmark. They have been used to guide on how the document is supposed to look like in future. They are not meant, Honorable Speaker, to be retrogressive in terms of the law, but to set the base against which we are going to the bill is going to appear in future. Thank you, Honorable Speaker.
Yeah. Thank you. Thank you for the information. But be that as it may, when I now look at clause 4, I'm not sure whether we are saying that World Bank is obligated to finance the agriculture and rural inclusive growth project into the future, or indeed that the German Development Bank will finance the drought resilience program into the future. I think there are some things, if they wanted to give by way of example, we probably don't need examples in the law. That can be done in regulations. But we can do a generic law and ask that regulation be done in terms of those schedules, so that when you look at a law, it tells you when this happens, you do this. You don't start saying
seriously, leader of majority, and going by the intervention by the minority whip. These figures have been put here as an example.
No.
I don't know. Proceed, leader of majority. That will be very interesting.
Indeed, from the title, the long title, says very clearly, an act of parliament to provide for the additional allocations to county government for the 2021-2022 financial year. Additional allocations. Now, the issue of additional allocations is within the framework of the National Assembly. We are the ones who appropriate the money, not the Senate. And if we continue with this, there's no reason why they cannot come next year and say we now want additional requirement. Then we'll be dragged through like we did in the past. So this is my issue, but I want us to interrogate. Perhaps they have a reason for doing it, but I would want to be convinced that indeed we are not talking of reopening the appropriations as we did without the framework of the Article 2 of the Supplementary Act, Appropriation Act, which is what I see happening through the back door. So, Honorable Speaker, like I said, we have time for this, and we can look at it together and see what is the rationale. If it's by way of example, then we can say example. But in an example, you don't then put specific people. We can say this is the template of how it will be, but without necessarily the figures. Because the figures will change year in, year out. The Germans may want to find out something now, but their funding priorities might change in the next year. And if you already put them in a template, you are basically saying we are expecting some money, which is not guaranteed. So I think that is the framework, the rationale with which I'm saying we look at this bill afresh and clean it up, and then we can pass it so that as we go into the new budgeting cycle, we will use the new law to now have the money is in terms of this is 370 for national revenue, which looks like a number that's been agreed. And then this is the money that will go through conditional grants. So much will go to this county and for this purpose. That I have no problem. But in terms of the attempting to put figures in 2021, 2022, and then pass it within a law, then we are basically saying, supposing the county of Nyandarua received less, and we are now telling them, Parliament has passed, you should have received this. They'll be asking for more money, yet we have not appropriated or even shown where that money will come from. So that's the spirit of my discussion on this. So, Honourable Speaker, like I said, the generic part is good. It's only when we come to the numbers, and usually they say the devil is in the detail. Those numbers could mean a lot if you don't take care or understand why they've been put there. And, we are told in West Africa, a toad does not jump in the daylight for nothing unless something is chasing it. So we need to just know what's chasing our toad to have these numbers coming in. With those remarks, Honourable Speaker, I beg to support with those reservations.
The Honourable Kathambi, Member Funjoro.
Speaker, thank you very much for giving me this opportunity to add my voice to the bill, the county government grants bill. Speaker, let me start by appreciating the committee on budget in relation with the appropriation of funds. And the Speaker, my just few points is to appreciate the proposed grants and loans, but also, Mr. Speaker, I think my main concern will be just to mention, when sometimes we talk about public participation in this country, it is taken for granted. Therefore, my first priority to say that when we are talking about these loans and grants, it's my push that the county government will be taking the serious responsibility to make sure that the public participation has taken place and in the right time so that people can give their views in relation with the entire matter. Also, Mr. Speaker, let me also take an opportunity to say that as I was trying to appreciate this document, and I've gone through what is proposed in relation to the loans and the grants. I was going to the matters of health as usual, credit, rural inclusivity, smart agriculture, devolution, water sanitation, primary health, Kenya devolution support, drought resilience program, emergency locust response, informal settlement improvement.
The Honorable Chepkone. The Honorable Chepkone.
Yes.
Is that mask useful to you?
I had a point to which I was to come up with the
No, the mask.
Yes, there must be a point I'm just coming up with.
I'm asking about the mask, where you're wearing it. Is it useful to you?
But Speaker, I thought I'm safe and everyone is safe because I have kept a very long distance. Actually, it's not even 1.5 meters. I've kept around 2 meters away. And the Speaker, to hand on that, I'm fully vaccinated. Therefore, I'm so safe. If you can allow me.
The Honorable Chepkone, let me just say this. It is not about you being vaccinated. It is just about keeping the others safe. It's about everybody. So the protocols are still applicable in the House. So we keep on the masks. But proceed.
Thank you, Mr. Speaker. And actually, I've kept all my colleagues safe because I'm very far from the majority, the whip, and also the noisemaker behind me. I've kept a lot of distance. Thank you, Mr. Speaker. When I was going through, though you have interrupted me, I was going through what is proposed for the loans and the grants, and I still have a lot of interest that. In the future, we have to look another dimension as a country. There is a global communication in relation with climate change in the world. But actually, most of the document, I don't see anything. The mask is really interfering with me. There is a concept of climate change, Mr. Speaker. Climate change has become real in the world. We have seen a lot of impact in our own country. Right now, northern part of Kenya, pastoralists are suffering with the livestock dying, lack of water. Mr. Speaker, when it rains in this country, there's a lot of floods, there's a lot of landslides, there's a lot of climate change impact in the country. We have seen a lot of deforestation, which has affected the rainfall cycle in the country, therefore also affecting the food security in the country. Therefore, Mr. Speaker, when I was going through this document, I realized there was nothing in the concept of the climate change, which is also affecting our country. And I hope in future we are going to, as a nation, like the Committee on Budget, also to be seeing these loopholes so that we can come up with a way to make it, to contribute to our country. And in relation to that also, Speaker, it is also good to say that recently in the United Kingdom Climate Change Conference, His Excellency the President was also giving the concept of what the country is doing by Kenya is going to have a program of stopping deforestation in the country. Therefore, in that climate change also, Mr. Speaker, I was saying, as we try also to talk about how to increase forest cover in the country, which has a positive impact in our country, that's why I'm saying this document, I actually saw nothing about it. That way it also became a matter of concern that in the future, let the Committee on Budget see that loophole. Therefore, I was saying, as we are talking about all these fantastic grants and loans being proposed, I have also an interest to message to pass to our governors. We have a challenge in this country whereby we can meet some governors. When they get money, they can sometimes do intentional action of taking money to their strongholds, ignoring other areas where probably they did not get votes. Therefore, we are also thinking that what we should also push from our governors to do is to ensure that there is fairness of distribution of these grants and loans to the respective wants in this country. And on that basis, Mr. Speaker, I'm also proposing that we should also have a very clear mechanism to ensure that the conditions set in relation with this grant and the loans is totally agreed and followed to the letter. Because sometimes we have conditions which sometimes are bad because of some reasons. Therefore, if we have such specific money for specific items, we would propose that let the governors be pushed to ensure these kind of funds are followed the right conditions. And my last point, Mr. Speaker, my last also comment, Mr. Speaker, we still have a lot of challenge in this country where we have a lot of minimal collection of revenues by governors. Therefore, I think we should also try to remind our respective governors in different counties that let them also come up with the clarity on how they can push for more collection of revenues, and not revenues which are just killing the economy to the bottom-up people. Therefore, Mr. Speaker, I still have to support this concept, which is good, and the bill, but it needs to be relooked to improve it where there are some loopholes. Thank you so much, Mr. Speaker. Thank you.
The Honorable David Ochen, member for Ugenya.
Thank you so much, Mr. Speaker. Mr. Speaker, I seek to support this very important bill, in my opinion. Mr. Speaker, for the last 8 years in the Assembly, we've bemoaned the way in which the national government has been treating these so-called grants, the arbitrariness with which they are treated, the lack of criteria through which they are given to the counties, and above all, the opaqueness with which the Treasury handles the grants. And so, from a macro level, Mr. Speaker, I want to support the Senate bill on county government grants, because, Mr. Speaker, it gives disciplines on how this country can deal with an eventuality that, every year there'll be monies that will be coming to the government that would be due to the counties, but you have no proper legal framework for doing so. And as the courts have confirmed, and as part of what we've been questioning in this assembly, how do we separate these two things? What is duly and legally, payable to the county governments, and what then goes to them as grants, whether conditional or non-conditional. And so this law provides for the disciplines through which the national government and the county governments will deal with reception, use, and accounting for these monies that go to the counties as grants. Mr. Speaker, this law, in my opinion, does one thing that runs through our constitution, that by requiring that agreements will be entered between the two levels of government, and that these agreements shall be approved by the county assemblies, it therefore means that for the first time the public gets to participate in the process of approval and use of these grants. And so therefore there are not opaque agreements between national government and the county government, Mr. Speaker, and this must be supported, Mr. Speaker. Number two, Mr. Speaker, and much as I agree with the Senate, but I want to fault it on one issue. This assembly has questioned severally the criteria used by the national government to give grants to counties to build headquarters. For example, the Honorable Deputy Leader has just talked about Nyandarua. So why did Nyandarua qualify first and not Siaya? What criteria was used to decide that it will be this county, not this one? Who made that decision? Why would some counties be required to use their own monies to build their headquarters and others get money from National Treasury? I would have imagined that the county, the Senate would also give a criteria of how these headquarters are going to, how the National Treasury is supposed to decide how these counties get money for building headquarters. Number two, Mr. Speaker, on the same breath at clause 4B, the now tired, in my opinion, the most stinking scandal of the year, in my opinion, the MESP, the medical equipment leasing, Mr. Speaker.
This is not the first time I'm going to see this kind of a project coming up. And so I would have imagined that you should have had disciplines from the Senate, because this is probably their forte, from the Senate, saying that if there would be any, in future, anything like this, then we expect these disciplines to be followed in terms of procurement, in terms of, because I've watched the governors coming to answer questions on MESP in the Senate. And all of them have said, we were forced to accept this equipment, whether we were ready to use them or not. And Mr. Speaker, it's on record that more than half the counties that receive this equipment don't use them because they don't have staff, they're not prepared to use them. And so we are paying so much money every year, but they're not being used. And so I would imagine that, and I hope we can propose amendments that would ensure that in case in future there's something like that happening, then again there are parameters and criteria and indicators on how best this can be done, so that you allow counties, give them the money, let them lease on their own, let them buy. There are those who would want to buy, there are those who want to lease, there are those who may have their priorities elsewhere. But you don't ram down their throats and say that you guys must accept radiology equipment, you must accept this theater equipment because we think they are necessary, without having trained personnel and all that. And so I would have imagined that there would be disciplines in this bill that Senate would require that before this kind of ventures are gone into, then counties must be consulted. They must agree, and therefore there's no time when national government will force anything on the county government, Mr. Speaker.
The Honorable Chair.
Yes, Mr. Speaker.
Without interrupting your train of thought on this, and this leasing, medical equipment leasing, that was, as you have said, forced on the counties. How come it has not been challenged in the courts? Because, I mean, doesn't it, if it is true that probably national leaders insisted that these counties must spend their money in this way, isn't that against the very spirit of devolution and therefore unconstitutional? I would like to just some thought on that.
Mr. Speaker, this has been challenged in court, and governors have protested. It's not just a court issue; it's been litigated, but it's also been a topic of debate, not just in this assembly, but in the Senate too. But Mr. Speaker, this particular thing about MESP was what you can describe how the deep state operates. They must take it. They have no option. And we had ministers coming to justify this. I used to be a member of the health committee. Mr. Speaker, there was no justification at all of not involving the counties and letting them choose what equipment they required. No, it was one size fits all. You take it or take it. There was no option of leaving. And even as we speak now, every year the Senate has been having these questions. Why are we paying for things we're not using? And so, Mr. Speaker, if you went to MTRH today, you'll find there an MRI machine that was supplied at 200 million shillings, but the market would give it to you at 70 or 80. Reason, it was brought to us by the national government. So it's scavenging. Basically corruption, conduit, that national government can decide that we're going to give this to counties. And that's why, Mr. Speaker, I'm saying that what was so much necessary in this particular bill is that the national government cannot pick and choose what they will send to the counties in money and what they will send to the counties in goods. It should be clear that the national government should not choose or procure unless asked by the relevant county. This is what I'm saying we should have seen in this bill, and I'm hoping that I'll have a chance to propose an amendment to this bill to reflect that position, Mr. Speaker. So, Speaker, I want to agree with the majority leader on the issue that appears now in 4.2. I mean, laws are made for posterity. And if we wanted to, improve what the court said, that we should separate the two, then we should make the law for posterity and say that in future this is the way you want grants to be handled. And not, you could have used 2021 as a benchmark, but you can't say it's only for 2021, 2022. And I also agree with them that you cannot, because you're being told is an example by the majority whip, but it's not. Because the wording here is that conditional allocations financed by proceeds, blah, 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 shall be as set out. So it's not an example. It is actually a law. Once it's passed, this is how this should be done. That's what 4.2 says now. It's not saying that, when you pass it, we will want it to be in this format of structure. So I agree with the majority leader on this, and I'm hoping, and I would like the whip and the majority leader to listen to this. Majority Leader and the Whip, if you allow, that we should not kill this bill. You must negotiate with the Senate. You must mediate so that this bill does not die the way other bills have died, Mr. Speaker. This is a very important bill, and we want to urge our leaders, both sides of leadership of the Assembly, that this bill is negotiated in a manner that we don't lose the bill. We don't leave this session or this Parliament without passing this bill. If they would allow negotiation without bashing Senate, you don't have to bash Senate all the time. You can agree with them that this is a good bill, like you said, principally, but you can change a few things so that this bill is passed before we go to elections, Mr. Speaker. Mr. Speaker, going forward, the other issue that I thought was quite important that should be raised in this bill, Mr. Speaker, is, again, the way the donors and the National Treasury agree on the counties that will benefit from the various projects that the donors fund. Mr. Speaker, in Rwanda here, it is the government that gives donors priorities, not donors giving government priorities. And I was even where, even us in Kenya, it's government that gives donors, these are our priorities. And these priorities fall in this belt, or this other belt, or this county, so that donors don't pick and choose, but our priorities choose for us, so that donors fit into what we are doing. It's worked very well for Rwanda, Mr. Speaker, and I thought it could work for us too. Mr. Speaker, equity in the way these grants are given to the counties is quite key, and I hope that we can agree that National Treasury does not, again, Mr. Speaker, gerrymandering, bureaucratic, individuals feeling that if you build Nyeri, you build the whole country. If you build Nyeri and you don't build Siaya, we are worse off as a people. If you build 3 referral hospitals in central Kenya, in Kiambu alone, and you don't build any in Western Kenya, we're all worse off.
The Honorable Chiang, I'll allow you an extra 2 minutes. I interrupted you.
The Speaker, I always don't understand, because in the last 5 years alone, we've had Kenyatta Hospital, Kenyatta University Hospital being built here, next door here. Then we have another one built in Nyeri, Othaya, a branch to Kenyatta National Hospital. Then we have now one being done in Gatundu, all within the distance of 100 kilometers. Now, where I come from in Siaya and Kisumu, we've begged to just upgrade Jomo Kenyatta Jaramogi Hospital to a referral hospital. No. The whole of Western region, from Naivasha all the way, we only have MTRH. We are worse off if only one region grows and the other regions don't grow, Mr. Speaker. And I wish that in future, Mr. Speaker, the government that comes in can plan equitably. This thing that if you are given a position and the only place that should benefit is your area, for me, I think it's stupidity. It doesn't help us. For those who went to school, that you go and when you're planning, you give roads to this region and leave the other region, and you think you are growing the country, Mr. Speaker. So I'm hoping that this particular bill can also streamline how the grants are administered, but above all, ensure that every part of the country benefit from donor support. Mr. Speaker, I beg to support this bill with the riders as indicated. Thank you.
Very well spoken, the Honorable Chiang. The Honorable Arbele Malimo, member for Laisamis.
Thank you so much, Mr. Speaker, for equally giving me this opportunity to add my voice into the county government's grants bill. Mr. Speaker, indeed, there is a lot of proposals, amendments, which have actually been...
The Honorable Malimo, just wear your mask appropriately.
Yeah, thank you, Mr. Speaker. As I had actually looked at the proposals made here, I agree with the proposals, but Mr. Speaker, these grants, which are actually being given to the counties, sometimes from European Union, World Bank, from Japan, other development partners, in support of some programs at the county. For instance, we have different programs in different counties, because I've seen like programs which support smart agriculture, health, for instance, energy sector, so forth and so on. Sometimes, Mr. Speaker, I have actually come across where the governors at the respective counties, just because these are non-conditional grants, they actually consider these funds as free money. So they end up actually using these funds sometimes to pay even for salaries, to pay for pending bills, to pay for other non-essential issues of the county, thus forgetting that these are funds which are actually allocated to the county so that they may be able to spark growth, development at the county level. And I've actually seen this a loophole where quite a number of counties, the governor, since he's the one actually who is in possession of these funds, he ends up misusing. So it is good that, because these are the funds, conditional grants, which is actually funds coming from the exchequer, it comes with conditions. And that is why many governors today, they happen to cry that they have not received funds.
KDIC, protecting your deposits.
Ili kupata skiza tune hii ya Galatians chapter 2 verse 20, bonyeza star 811 star 397 hash.
Galatians 2 verse 20. I have been crucified with Christ, and I no longer live, but Christ lives in me. The life I now live in the body, I live by faith in the Son of God, who loved me and gave himself for me.
Ili kupata skiza tune hii ya Galatians chapter 2 verse 20, bonyeza star 811 star 397 hash.
The Kenya Medical Training College will hold its 90th graduation ceremony on December 2nd, 2021. Visit www.kmtc.ac.ke for more information on the graduation, training programs, and application procedure. KMTC, training for better health.
To check it around, and Madam Wazile will tell you for sure, we have received approximately now 3,000 ideas so far, and we are looking to see whether we can even receive much more. I guess by now the number has gone high because the students from this university, many of them also participate in this challenge, quite a number of them, and we are looking to see whether we can be able to get even many more ideas across. And our motivation theme, how do we really create that culture, creative thinking, and innovation young people, so that if we are able to convert many students to be like Hilda here, who started as a student in university and decided that it was possible for her to convert what she was doing and make it a business, and since then she is now an entrepreneur. She is now an entrepreneur. If we could be able to do so, that is the direction. So when we came and had a conversation with the management of the university, the dean and other directors around her office, his office, and we discussed, we were asking ourselves, because now the university has quite a number of faculties and we have quite a number of problem statements that you go to our website, you see quite a number of problem statements, because there are two ways you can send ideas to us, or rather there are two ways you can participate. You can either consider to send your original idea, or you can go to our website or our check our social handles. Even now you will see quite a number of problem statements we have posted there. You can decide that you want to participate or you want to attend problem statements and if you send the most creative and innovative idea, then we guarantee you the four things. So when we were having the conversation with the dean and the management, we were asking ourselves, what is that one opportunity, or what is that one area sector that we can try and attempt going to cross all the faculties and a very brilliant idea, and I want to thank the team, and I also want to thank Karen, who also participated to assist us to come up with a question. They agreed that the best question, or rather the best problem statement we could put across by then